Brings us to the next item of business, which is a debate on motion number 7106 in the name of Paul Wheelhouse on the Crofting Amendment Scotland Bill. Can I invite members who wish to speak in this debate to press the request to speak buttons now? And I call on Paul Wheelhouse to speak to and move the motion. Minister, in 9 minutes or less, if possible. Thank you.
Thank you, Presiding Officer. It gives me great pleasure to be standing here today opening the Stage 3 debate on the Crofting Amendment Scotland Bill. It is especially pleasing since it is clear to me that there is strong support across the Chamber for this bill, and the owner-occupier crofters should soon be able to apply to the Crofting Commission to decroft their land. I recognise there has been a debate about the drafting of the bill. The level of support, though, received from almost all quarters for the Scottish Government to put in place measures to resolve this issue makes the hard work and effort put into resolving this issue extremely worthwhile, and the bipartisan approach taken by colleagues across the Chamber, I think, sets a good example of how this Parliament can operate. Given the known complexities of crofting law, which I have recognised, who would have thought a satisfactory conclusion was possible before the summer recess? But here we are facing that very prospect. At its most fundamental level, Presiding Officer, as drafted, the bill does what it says on the tin. It allows owner-occupier crofters to apply to decroft their land and grants the power to the Crofting Commission to issue decrofting directions. The bill also gives retrospective effect to the legislation to ensure that owner-occupier decrofting decisions taken previously by the Commission are competent. The bill also provides a right of appeal for those who may have been dissuaded from appealing a decision after the Commission announced in February that it could no longer accept these applications. When this issue was first brought to my attention, my initial reaction was to consider why the legislation was framed in the way it is. I also considered whether there was an alternative administrative solution, as had been suggested by some stakeholders. But rather than dwell on the past or give further consideration to work around solutions that might fail, I quickly concluded that a robust fix was required. I decided that it would be far better to focus on a legislative fix that would leave no doubt that the legislation would deliver the initial policy intent. Given the range of diverging legal opinion, it was clear that existing legislation did not do that. There was also evidence that people were being adversely affected, so a solution had to be put in place quickly. That is why I asked Parliament to consider an expedited process for this bill, and that is why Parliament agreed to this approach. Whilst the process has been successful, it has also been challenging. The strict timetables, ensuring all matters were carefully considered, and providing stakeholders with an opportunity to contribute were particularly important. The expedited process was justified in this case because owner-occupier crofters were disadvantaged, but that does not mean it should become the norm. Some called for emergency legislation. However, I wanted to ensure that this Parliament could have the opportunity to carefully consider the bill and apply an appropriate level of scrutiny. And I'm satisfied that Parliament has gone through that necessary process to ensure that this bill will deliver its purpose, and the Raki Committee and a number of learned legal witnesses concluded that it does. As I've said already, I have no doubt that it does deliver what is intended, and I'm pleased there is broad consensus on this. However, as I already mentioned, I recognise that there have been differing views on how legislation could or should be drafted. I consider that I have addressed this along with other issues during stages 1 and 2 of the bill. We now have an opportunity to ensure that we help those owner-occupier crofters who have been unintentionally disadvantaged as a result of a specific flaw in the Crofting Reform Scotland Act 2010. So I want to focus on the bill and its intentionally narrow scope. I also want to take the opportunity to briefly explain why the Scottish Government has not brought any amendments forward. Before Stage 2, I considered carefully all of the issues raised in light of the Rural Affairs, Climate Change and Environment Committee's Stage 1 report. The Scottish Government responded to that report in writing on Tuesday the 11th of June and set out its position on various issues raised. The committee's Stage 1 report recommended that the Scottish Government give appropriate consideration to whether any of the issues raised required amendments to be brought forward. I gave detailed and careful consideration to Sir Crispin Agnew's views and the views of others on drafting and sought an appropriate level of assurance that the bill was fit for purpose. Following due consideration, I concluded that the bill as drafted achieves its purpose. It provides the necessary clarity and legal certainty to solve the problem it set out to address. That view was supported by the committee in its Stage 1 report. The committee also recommended that the Scottish Government give careful consideration to the views expressed on a number of things, including the definition of decrofting direction, the application of Section 25 of the Crofters Scotland Act 1993, and the protection of access to croft land. Again, the Scottish Government has addressed these issues in its response to the committee's Stage 1 report. On retrospection, I welcome the committee's support for these provisions. The bill ensures that all 159 decrofting directions and the 44 cases held in abeyance are competent. Also, The Crofting Commission has said it would deal with all outstanding decrofting applications as quickly as possible, and I'm very grateful for that. As I've said previously, the ability to decroft should not provide an opportunity to speculate on croft land to the detriment of crofting. We all have a responsibility to ensure that crofting remains sustainable for our future generations to come. No government can do that alone. We need to establish and maintain cross-party support to ensure that crofting remains sustainable and continues to deliver benefits. The committee's Stage 1 report and the Scottish Government's response also addressed issues not included in the bill. I'm all too aware that there are other issues to be addressed, both legislative and administrative. However, that will not happen overnight. We all need some time to take stock. We need to ensure that what we do next is right for crofting and right for remote rural Scotland. That will take some very careful consideration, and it is only right that such consideration involves the key stakeholders. I do not think that another committee of inquiry in crofting is required, but I do think that the other issues highlighted during the course of this bill need to be addressed. They need to be addressed carefully, fairly and objectively if we're to ensure that crofting continues to provide cultural, social, economic and high nature value farming benefits. That is why I gave an undertaking to this Parliament during Stage 1 of the bill that my officials will investigate in consultation with stakeholders what the best method might be for dealing with the outstanding issues. Stakeholders should therefore expect contact from my officials to arrange a discussion on the next steps for crofting. And I won't attempt to cover all the points here, but I can assure this Parliament that all issues were carefully considered. I accept that I'm still a relatively new minister with a direct portfolio interest in crofting, but I have already had the opportunity to visit the crofting counties on a number of occasions, and I've seen for myself the benefits that crofting delivers. Strong communities working together to ensure land is worked in a beneficial and sustainable way. Innovative crofters contributing to the economic vitality of local economies across the crofting counties. The breathtaking landscape, environment and hospitality that we can all enjoy as a result of crofters' hard work and stewardship of Scotland's countryside. And the particular strong contribution to the cultural diversity of this great country, whether that be in our island communities or on the mainland. These attributes align very closely to the Scottish Government's purpose and reflect the national outcomes and priorities we are delivering. This bill will not solve all the challenges that crofting brings. However, it does ensure that this particular decrofting issue is resolved as quickly and as fairly as possible. There has been a concerted team effort in the development of this bill, and I would like to thank those who have played a part in getting us to this point. First, I would like to thank the Rural Affairs, Climate Change and Environment Committee and their clerks, who have, with their characteristic good grace, taken on the challenge of the expedited process and ensured that the appropriate consultation and scrutiny of the bill took place. I would also like to give my own sincere thanks to all those who gave evidence and contributed to Parliament's deliberations on the bill. These include the Crofting Commission, the Crofting Federation, the National Farmers Union of Scotland, Scottish Land and Estates and other organisations, legal specialists in crofting law and other individuals. And I'm extremely grateful to them all for their contributions. And I would also like to thank officials, both in Parliament and in Government, who have worked tirelessly to give us a bill that meets its purpose. Finally, I would like to thank members across the Chamber for the consideration they've given to what is a complex area of law. Presiding Officer, we have worked together to get this far, and I hope that we can all, once again, work together to ensure this bill is passed for royal assent and is put on the statute books as soon as possible, to bring an end to the uncertainty that has caused such difficulty for individuals. Presiding Officer, I commend this bill to the Scottish Parliament and move motion S4M 07106 that Parliament agrees that the Crofting Amendment Scotland Bill be passed. Thank you.
Many thanks. I now call on Claudia Beamish with a maximum of 6 minutes.
Thank you, Presiding Officer. Scottish Labour is optimistic at Stage 3 of this bill, in spite of the complexities involved, that it will be passed with the cross-party support that's been shown in the Chamber, and will rectify the problem faced by those affected by the flaw in the 2010 Act in relation to owner-occupier crofters and the decrofting of land. In the Stage 1 debate, I highlighted Scottish Labour's concerns about the need for all possible amendments to be lodged at Stage 2 to enable committee and parliamentary scrutiny. In an expedited process, of course, the pressures are much greater, with little time between stages, so I would like to thank all those involved in moving things forward quickly. And as it turns out, there were no amendments at Stage 2 or indeed at Stage 3. However, I would also like to thank the Minister for clarification provided at Stage 2. The Minister's explanation at Stage 2 in his opening remarks before our committee reassured us that the Scottish Government legal team had looked at the alternative suggested wordings, and I now want to take a short time to highlight some of the Minister's remarks. The Scottish Government considered the detailed drafting issues that were raised. I can promise the committee that they have gone over them in some detail. However, as it is drafted, the bill achieves its purpose. A number of key witnesses to the committee all agreed that the bill delivers on the purpose that the government has set out in giving owner-occupiers the ability to decroft. So this reassurance was given, and there hasn't been any comeback on that. It was right that there was a truncated process in Scottish Labour's view to enable those in limbo due to the 44 applications being put on hold by the Crofting Commission to proceed, and for those who were unable to apply to decroft to be considered. And if this bill is passed today, it will be very important that this is a speedy process, and I do seek reassurance from the Minister in his closing remarks that this will indeed be the case. There are other issues that were raised with our committee in relation to the decrofting during evidence taken on the bill, amongst which house building, diversification, renewable energy development, and foremost, among other issues, the definition of what constitutes an owner-occupier crofter and issues facing multiple owners of distinct parts of the same croft. Scottish Labour is of the view that it was right to consider these and other decrofting issues after this bill in order to ensure the appropriate consultation process, as highlighted by the Minister today. And I believe that you have already highlighted for us the time frame for proceeding with that. Perhaps the only thing that we all seem to be clear about is the opaque nature of crofting law. The Stage 1 debate produced a number of interesting points from members, not least Alec Ferguson's metaphor of crofting legislation being like the mythical Hydra. As soon as you think one aspect of the legislation is sorted out, another two problems arise. If Alex Ferguson wanted to continue his classical references, his answer to the problem of crofting law might be compared to Alexander the Great's creative solution to untangling the Gordian knot. Rather than repeatedly trying to untangle the knot, perhaps the best solution could be simply to cut through with a single standalone piece of legislation. This may or may not be the way forward, and it is for us all to work together as best we can to find out what is the best way for crofters in the future. Before closing, I want to highlight some new thoughts in relation to crofting. Nourish Scotland is a non-profit organisation, I quote, set up to develop and promote a fairer and more sustainable food system in Scotland. This is at a time when increasing numbers of our citizens are becoming dependent on food banks, as I witnessed on Saturday when attending the official opening of the Clydesdale Food Bank. Nourish argues that access to suitable land is one of the most significant barriers to developing a vibrant local food economy in most parts of Scotland. It is argued there is a demand for small productive units and that the Crofting Commission at present holds a waiting list of 150 in existing crofting areas. Nourish calls for a target of 10,000 new crofts in 2020 across Scotland. Whatever you think of this suggestion, it is certainly food for thought. And the Scottish Crofting Federation states, I quote, "The development of crofting is the most appropriate model of land tenure for Scotland to achieve a food system that is environmentally sustainable, socially beneficial, and a source of healthy, tasty food for the long term." Whatever you think of this suggestion, it is certainly food for thought. Many of the issues raised during the passage of the bill beg questions about the structure of land ownership here in Scotland and the tenure across our country. These debates and decisions are for another day, and Scottish Labour is certainly committed to addressing them, along with others. For today, though, we support the passage of the bill to become an act and wish all those crofters affected a speedy and satisfactory solution. Thank you.
Many thanks. And I now call on Alex Ferguson. 4 minutes, please.
I think I was advised I had 5 minutes, Presiding Officer. Is that not the case?
4 minutes, I'm afraid.
4 minutes, right. Presiding Officer, I ended my contribution to the first debate by saying that I wasn't particularly looking forward to stage 2. And I said that because I felt pretty certain that the government would be bringing forward some amendments to address the concerns that had been raised by eminent specialists in crofting law in evidence to our committee. Now, I don't want to simply repeat the arguments that most members made during stage 1 debate, but I think we can all agree that crofting law is a nightmare of complexity which tends to throw up a plethora of unintended consequences whenever it is tinkered with. We all witnessed these eminent expert lawyers I'm not sure what Freud would have to say about that, presiding officer. These eminent expert lawyers plainly disagreeing with each other, although I think it should be noted that the 2012 meeting of the Crofting Law Group agreed unanimously that this bill would need amendment. Now, during evidence, Crispin Agnew raised a number of concerns, not about whether the bill would actually address the unintended consequences of Parliament's previous efforts to amend Crofting law in 2010, but about the lack of integration with the 1993 Act. And he said of the bill, the provisions are a complicated set of sections that stand alone, with no attempt to integrate them with the rest of the 1993 Act. Problems may arise from that. There is no clear link to all the various sections. It is very difficult to achieve that in Crofting context, but that is my concern. The legislation is perhaps overcomplicated. Sir Crispin went on to deal with a number of examples within this bill where he felt that greater simplicity was needed to provide a greater degree of clarity in an area of legislation that we all now know badly needs it. And in one of his final comments to the committee, he said quite simply, this bill is vague. Now, given that evidence and more, I was therefore quite surprised that the Minister did not bring some amendments forward at stage 2, and I asked him why he had not done so at the committee meeting on Wednesday, the 12th of June. His reply was essentially that having examined the bill in the light of stage 1 evidence, his team was satisfied that the bill would achieve its purpose. But, presiding officer, no one was actually questioning that. The questions, the concerns that were raised, were over whether the drafting of the bill was likely to give rise to further unforeseen consequences. Now, in his response to me, the Minister went on to say the Scottish Government is committed to drafting in as plain and accessible a manner as is consistent with achieving the necessary outcome. So given that statement, I can't help but agree with Brian Inkster when he says that it would have been useful to have seen a detailed rebuttal of why the concerns raised with the committee apparently did not need to be addressed. That level of detail is something, sadly, that has been lost in the urgency that is required to pass this legislation. So I take the Minister at his word. My knowledge of the subject is not detailed enough to do otherwise, but I did suggest in an earlier debate that this could come back to haunt him. Now, I genuinely hope that I'm wrong in that prediction, but I couldn't help but notice a further quotation from Mr Inkster, which says, the Crofting lawyers in question have actively tried to reduce their workload by seeking to assist the Scottish Government in the drafting process. But the Scottish Government, in rejecting that assistance, appears content to increase the workload those lawyers will have by adding to the complexity of Crofting law. So be it for now. And so be it for now, I guess it has to be, presiding officer, because we must all sincerely hope that the pluses of this bill greatly outweigh the minuses. We all played a part, or most of us did, in the creation of this problem, and as I said at stage 1, it is a clear measure of the complexity of Crofting law that no one, neither government, parliament nor legal experts, picked up on it at the time. So we support the government in its efforts to secure this bill. We think it is right to do so. If nothing else, presiding officer, the retrospective aspect of this bill will ensure that the 159 crofters whose applications have been processed can once again sleep soundly in their beds, knowing that the law is once again firmly on their sides. We will support this bill at decision time.
Many thanks. We now turn to the open debate. I'm afraid time is very tight. Speeches of a maximum of 4 minutes. Rob Gibson, to be followed by Jane Baxter.
Thank you, Presiding Officer. I'd like to support the fact that the bill clarifies where owner-occupier crofters stand on decrofting and restores the policy intention of the 2010 Act. And for an outset, I would like to put on record my deprecation of anyone who infers that the Minister, the officers and the Rural Committee in 2010 did a rushed job. Their intentions were indeed honourable, and naturally this Parliament will give post-legislative scrutiny to all acts of Parliament. This work is partly achieved in the Crofting Amendment Bill today, but will be achieved in various other ways which have been mentioned already. Now, the Crofting lawyers who discussed this obviously have a wealth of knowledge, but, you know, many of them accepted that the fact is that this bill covered the narrow point that needed to be cleared, and our committee was absolutely unanimous in agreeing that that was so. That means that we can allow those nearly 200 people to move on as quickly as possible. Now, the Scottish Government responded to the kinds of criticisms that have been made, but really, you know, when you're asking governments to reveal their legal knowledge, surely the message must go out, they do not. It doesn't matter which government it was, so lawyers or others who are asking for this kind of information, Presiding Officer, should desist. It isn't going to happen. But what we can have is a debate when the government comes forward with the means to discuss the different points which have been raised in the other part of this report that we're discussing today. Now, we can see that the arguments about owner-occupiers and owner-occupier crofters are something which has taxed many of these critics. But it's quite simple. You can register as an owner-occupier crofter, and that allows you then to participate of this Act and to give protection for you if you wish to decroft. So to those people who are arguing that certain owner-occupiers who are crofters out there are concerned, that's the simple answer. Get registered, and I think then we can deal with some of the other matters as they come along. It may be that, the Parliament is treated increasingly and politicians as some kind of joke. Certain discussions about a sort of crofting song contest suggested that our committee should get 6 out of 10 for trying. Frankly, does not reflect the seriousness and the intent with which we dealt with these matters, and I'd like to put on record my concern that those people who wish to make those kind of remarks should leave that to us to make remarks of that sort, and if they are lawyers, to offer us advice, not headlines.
Final minute.
I'm sorry to say that that happened on more than one occasion, and that when Ailey I.M. Ross of Inkster Solicitors gave a written evidence statement that it is simply not acceptable that the legislative framework which supports that system is such a shambles. It is not a shambles, it is not a mess, it is a matter of complexity which we have inherited and indeed which stems back to pre-devolution days, to the 1993 Act and before. And it's something which will take time to sort out. I said in an intervention when Tavish Scott asked me in the last debate about this, can't we do some consolidation? I said it would take double committee meetings twice a week probably for the next 5 years. And if that's so, we can't approach it that way. This bill deals with the simple point. There are others which have to be dealt with, and I look forward to dealing with them, if we can, in a simpler fashion in our committee. Meanwhile, I support the bill today and hope it becomes an act.
Many thanks. I now call Jane Baxter to be followed by Tavish Scott.
Thank you, Deputy Presiding Officer. I spoke at some length in my contribution at stage 1 about some of the issues which have led us to the situation of having to amend such recent legislation, so I do not intend to revisit those points. For those crofters currently attempting to decroft and who find themselves in limbo, or even for the sake of those who wish to begin such a course of action, it is clear that we must make progress on trying to fix the existing problems. MSPs from all parties recognise the general provisions of this bill, and I therefore look forward to it being passed this afternoon. I am aware, however, that the Crofting Law Group remain concerned about this legislation, and I hope, therefore, that Ministers and the Crofting Commission will be vigilant in monitoring the implementation of this legislation and its effectiveness. Because, although we have spent much of our debates noting how baffling the complexity of crofting law is, what has come through clearly, even amidst the confused tangle of crofting reform legislation, is the importance of crofting to communities in huge swathes of rural Scotland. From my MSP colleagues across the Chamber who assiduously represent their constituents in the crofting counties, I have learned that crofting is not just a business or a house or even a small farm. It is all of these things and more, and crofts are integral to preserving the heritage and communities of many parts of the north and west of Scotland. The Scottish Crofting Federation has highlighted that for crofting to survive, we need not just security of tenure, but viability for crofters and their crofts too. A community's viability is dependent on many things: its economy, its transport links, its services, but at the heart of all of that are its people. The most successful communities have a diverse population that will flourish and can sustain it in the future. When we look at the Scottish Government's own figures on population for rural areas, we can see how fragile some communities are. While just over half, that is 53%, of the population of remote rural areas are aged 45 and over, only 17% are in the 16 to 34-year-old category. This compares with 42% and 26% respectively for the rest of Scotland. So at either end of the scale, remote rural Scotland's demographic outlies the rest of the country. Such figures can illustrate how Crofting is not immune to the challenges being faced by other sections of remote rural communities, with the loss of young people away from where they grew up and an increasingly older population. The Scottish Crofting Federation has noted how important new entrants are to the future of crofting if it is to continue, so we must have a framework for crofting which is accessible and will encourage people to get involved. So to finish, Presiding Officer, I am grateful that we have reached stage 3 of this urgent legislation ahead of the summer recess, and I hope that the Crofting Commission will take appropriate action as soon as possible to help crofters who wish to decroft to get their plans back on track. Thank you.
Many thanks. I now call Tavish Scott to be followed by Jean Urquhart.
Thank you, Deputy Presiding Officer. Can I firstly thank the Minister for the courteous way in which he's handled this bill. It enormously helps those of us who do represent constituents in the Crofting counties if we have a Minister who's prepared to listen to the argument, and I want to recognise that Paul Wheelhouse has done exactly that. I also want to thank Mr Gibson and his colleagues on the Race Committee, always seems a strange title, the Race Committee, but let me just call it the Rural Committee, for their forbearance in dealing with complex matters now and undoubtedly in the future. But above all, I want to thank the crofters in Shetland who brought this shambles to my attention in the first place as it affected owner-occupiers in the islands. I'm pleased the government have taken forward this measure. I support it, as my party will tonight, but I do believe, as the Minister recognised, there is an awful lot more to do. The Minister mentioned the other fixes that are going to be necessary. They are considerable and varied, as other members have mentioned, and I ask the Minister to consider in the points he made about how he plans and his department plan to address those needs, that, for example, officials visit Shetland, visit other Crofting counties, so as to hear at first hand, and they will, dare I say it, the practical consequences, the practical difficulties that many crofters now face. I also welcome the fact the Minister said no to Shucksworth 2. I rather agree with that position. I think the issue is to get on and sort the problems that undoubtedly exist. I also take Mr Gibson's point about government legal advice, but I think there's a big difference, I'm sure he'd recognise, between that and that of the Crofting Commission's legal advice. I don't think the Crofting Commission can be allowed to get away with simply hiding behind their legal advice, which is their position increasingly to those of us who are making representations to them on behalf of constituents. Now, I don't expect and would not expect the Minister to answer that today, but I think we are in the wrong place if now crofters who are trying to resolve, yes, complex, but in other ways straightforward issues, are constantly told by the Commission that they must take their own legal advice without having any opportunity to find ways to question what legal advice the Commission has taken at taxpayers' expense, I may add, at the expense of crofters around the Crofting counties. So I would hope the Minister might consider how to best challenge that issue, given the considerable powers, I may say, that he and his colleagues have in respect of the bill that, or the Act, I should say, that Mr Gibson mentioned a moment or two ago. There are some in the Crofting counties who are very concerned that the entire regime of law, the entire edifice that is Crofting law, could literally collapse if concrete steps aren't taken to put it on a much more level footing. Now, that won't happen, of course, overnight, but there are people I respect who know this inside out, who say this is absolutely at the tipping point. So the Minister's rightly dealt with the current problem, but there is much more to do. Two final points, Deputy Presiding Officer. The first, as others have recognised, is what we should be debating about crofting is about the production of quality beef and lamb around the counties, about the livestock that the Crofting counties produce for breeding both in cattle and in sheep, about local food and about active local people in strong rural and island communities. That's what we should be debating. But I suspect that what we may be debating in the coming months will be the September Crofting Law Reform Conference to be held in the Signet Library here in Edinburgh. It now looks like too many of us will have to go along and listen at that to the lawyers who I think Mr Ferguson really described as criminals, which I might or might not have agreed with at the time. And we'll find out after that conference whether I would agree with him on that. But nevertheless, who are going to debate these issues inside out. I hope that by the time some of us do attend that and listen carefully to what is said, the Minister might have had a chance over the course of the summer months with his officials to pull together some thoughts about the best way forward. On that, I'm sure we could all agree.
Thank you very much. I now call Jean Urquhart to be followed by Nigel Dawn.
Thank you, Deputy Presiding Officer. I'd like to commend the Scottish Government, as others have done, for the manner and punctuality with which they've addressed the issue. I'd also like to thank the Raki Committee and SPICE for their helpful reports on the bill, which aid considerably in untangling some of the complexities of crofting legislation. I'm aware of the calls to include further crofting changes in this bill, which I believe would only have complicated and perhaps diluted the reasons for the emergency procedure, and it was therefore prudent to leave these other considerations until after the recess and focus exclusively on decrofting rights for owner-occupier crofters. As I understand it, there are a number of issues surrounding the exact rights for owner-occupier crofter versus owner-occupiers, and that the Minister indicated during the Stage 1 debate that he would seek to clarify exactly how many owner-occupiers who are not owner-occupier crofters have been caught up in the decrofting problems. Although technically out with the scope of this particular bill, it is an indication of the many holes in the fabric of crofting legislation that require resolution sooner rather than later. I trust that the Government will continue to do what it can to clarify and simplify crofting law in the near future, and I'm sure the Minister has noted Brian Inkster's comments regarding the length and complexity even of this amendment bill, and his opinion that there is not only an opportunity but a necessity for the Scottish Government to simplify crofting law. Obviously, decrofting is the pressing issue, and to tack on other issues in crofting legislation to this amendment bill would have slowed down the process considerably. I am aware that the Crofting Law Group, as mentioned by Tavish Scott, is meeting on September the 27th for their annual conference and will be discussing crofting law reform. I would be really keen to see the Government continue to consult with the group and with those in the crofting communities on the possibility of bringing forward further legislation after the recess to consolidate and simplify other existing legislation. But given the nuances and peculiarities of crofting, the various legal interpretations offered during the committee's evidence gathering and the expedited nature of that evidence gathering, I would again like to commend the Scottish Government for their responsible and expedient approach. It truly reflects well on the Parliament when a problem can be identified and corrected, no matter its origin, the origin of the mistake. For the benefit of the crofters of Scotland, we must now pass this amendment, and then after recess we can focus on the other areas of crofting legislation which desperately need change. I support the bill.
Thank you very much. And finally, Nigel Dawn.
Mr. Presiding Officer, I'd like to begin, as my colleague Graham did last time, by picking up on what Derek Flynn told us in committee evidence from the Scottish Crofting Federation. He started by saying, the point is that owner-occupiers are not entitled to occupy their crofts. I deliberately foreshorten his quote, partly because of time, but partly because it just introduces to anybody who's coming to this debate rather late and looking at the official report quite how complicated this whole subject is. How can that statement conceivably right? I think I now understand why it's true, but I'm not sure that I would want to explain it to anybody else. And I noted, as I sat on the committee, that Sir Crispin Agnew came along and immediately criticised this, that and the other. We've had comments from Brian Inkster, which have been referred to already, and some even this weekend. What is abundantly clear to us, and I happily put it on the record, is that even the experts cannot agree. Now, I don't hold that against them. That simply tells me that this is an enormously complex area of law. We need to recognise that. Am I sure that we're doing absolutely the right thing this afternoon? No, I'm not. But I am sure I have confidence in the Government is doing its level best to get the right answer. And on that basis, I will be very happy to support it this afternoon. I'd like to briefly reflect, Presiding Officer, on the timetable in which we've been working. This isn't a normal legislative timetable, we know that. This has been an expedited procedure. The alternative would have been an emergency procedure. Many of us went through that last time round in the previous session. That was when there was no time to lose. That was when we had a Court of Appeal decision about criminal procedure, and quite frankly, we had to fix it more or less overnight if we were to be sure that our policemen could continue to arrest people and lock them up. That would not, I think, have been the appropriate procedure, and I think with the benefit of the past few weeks and seeing the evidence that's come before us, it's now entirely clear to me that that would have been the wrong procedure. So I would like to confirm on the basis of the evidence that we now have of going through it, that this expedited procedure seems to have been the right way to do it. So well done to those who made that decision. Can I also offer our thanks, genuine thanks, to all those experts who wrote to us and came and spoke to us. No doubt at fairly short notice and some inconvenience. I think we really could not have done without that. That is very much appreciated, even if we didn't understand everything that they said. Is this the end of the road in the debate about crofting law? Plainly not. I'm only repeating what others have already said. I am very grateful that the Minister has just said we're going to have time to take stock. I'm sure that's the right answer. And I'm grateful to Tavish Scott for his comments about what we should be talking about, which is the agriculture and the people and the communities, because really that is what this should be about. It's actually what land law should always be about. And the fact that we're having to worry about the minutiae of how bits of legislation fit together merely confirms the complex position to which we've got ourselves, and one from which it would be very nice to extricate ourselves. There's only just one other thought, Presiding Officer, at this stage of proceeding, and that is just to note that we have retrospective application of this bill, something we should always be very careful about. Generally speaking, we should know what the law is going to be in advance. We shouldn't be fiddling with it afterwards. I think we know fine well where we're doing it on this occasion, and again, I can only repeat my hope that we've actually got it right, that it does actually provide some certainty for those who've been inconvenienced over the past months, and let's just hope that that's what it's going to achieve. Thank you.
Thank you very much. We now turn to closing speeches and a call on Jamie McGregor. 4 minutes, please.
Thank you. I'm pleased to close today's debate for the Scottish Conservatives and hope that it will bring closure to this subject, although I somehow doubt it. I again thank the members and clerking team of the Rural Affairs, Climate Change and Environment Committee for their work on this bill against a very tight timetable. As we've said consistently, since this unfortunate issue arose, we will support the passing of this bill at stage 3 today, as it is appropriate that action is taken swiftly to remedy the legal limbo in which owner-occupier crofters who wish to decroft have found themselves through no fault of their own. And I'm pleased that the Crofting Commission has indicated it will process the outstanding application to decroft as quickly as possible and will be able to prioritise cases if particular deadlines face the individual crofters concerned. While we accept that this bill provides the necessary clarity to remedy the specific issue in terms of owner-occupier crofters, a big theme of the Stage 1 debate and the committee's report, and indeed today's debate, has been the concern that exists about a significant number of other apparent issues and anomalies arising from the 2010 Act. Now, some of these were voiced by members of the cross-party group on crofting, which I convened last Wednesday evening in the Parliament. They include concerns about the decrofting of a croft where there are multiple owners, and the position of owner-occupiers who are not owner-occupier crofters, and whether the first purchase of a tenanted croft triggers registration. Brian Inkster told our cross-party group that members of the Crofting Law Group will be gathering these issues and discussing them in the months ahead in advance of the group's annual conference in September, and I welcome this and would encourage the Minister and his officials to engage constructively with the Crofting Law Group, which has a very significant amount of legal expertise, as the government moves forward and seeks to address these issues. Before concluding, I want to raise another specific concern in relation to the 2010 Act that was highlighted at our cross-party group. This is in relation to crofters who register their crofts having to place an advert to that effect in the local newspaper, which can cost up to £100. And as Derek Flynn, chairman of the SCF, said to the Rural Affairs Committee, if every crofter who has a croft, and there are 18,000 croft, has to pay £100 to explain that he has his croft in the register, Crofting is paying 1.8 million to advertise the fact that the crofts are being put on the register. And for what purpose, Minister? And it's a lot of money. And I wonder if the Minister will comment on this and say whether he might look at the issue. Concern was also expressed at which body in Scotland will actively support the development of new crofts. Crofting development, as opposed to the crofting community development, is, for example, not within HIE's remit. We were told that by Neil Ross of HIE at the cross-party group on Wednesday. There must be clarification about which body is promoting crofting, and especially new crofts. To conclude, we support today's bill, but we want ministers to look carefully at and respond to the many issues which have arisen in consideration of this bill. Crofters deserve clarity from their legislators, and we want to have a legal underpinning for the sector that can't underpin anything here. A legal underpinning that is robust and understandable, so we can focus properly on the policies that we can adopt to sustain the crofting sector and encourage it to develop in the years ahead. Thank you.
Thank you very much. And now call on Claire Baker. 5 minutes, please.
Thank you, Deputy Presiding Officer. The Crofting Amendment Bill has been quickly delivered through Parliament, and I'm pleased that we're concluding this process before recess. We all understand the unintended consequences that transpired from the 2010 Act and know the reason why this bill is needed. Of course, the Minister cannot give an absolute guarantee there will be no further challenges, but the Parliament must be confident, as it can be, that not only is the problem of owner-occupier decrofting being resolved, but that going forward we can be confident in our crofting legislation in general. We should not forget that while we spend time bemoaning the complexity of the legislation, it can impact significantly on people's livelihoods and resources. As Peter Peacock highlighted during the passing of the original Crofting Reform Bill, with the passage of every successive bill on crofting, it is almost inevitable that regulation becomes more complex. The complexity of not just this amending bill, but of crofting law in general, is known to many, if not everyone, in the Chamber today. Many stakeholders use the process of this bill as an opportunity to express their frustration with crofting law in general and discuss wider issues than those that are included in the bill we are passing today. While this bill deals with an issue that is time-sensitive, I do welcome the Minister's comments on where the Scottish Government will go next on crofting, and Tavish Scott gave a summary of some of the key issues needing to be faced. It is important that the discussion on crofting continues after this afternoon. We must carefully consider the evidence raised by experts and stakeholders in the committee during the scrutiny of the bill. We have been made aware of one unintended consequence of the 2010 Act, but we should not be complacent in believing that further challenges in the field of crofting legislation will not come to light. For example, the definition of the term decrofting direction and protection of access to crofting land have not been fully addressed, nor has the complexities that arise if one of a group of multiple owners decides to decroft, with the Scottish Government's own head of crofting services indicating that multiple ownership issue may affect up to 700 people. This is not an insignificant problem, and one that can hopefully be addressed by the Minister. There are some 18,000 crofts across Scotland, housing more than 33,000 people. Nearly 70% of our national natural reserves and 60% of our sites of special scientific interest lie within crofting counties. Crofters bring many benefits to our country, but they also face many challenges. These challenges are economic in their nature, and as a Parliament we should be doing all we can within our powers to help them, and James Baxter spoke this afternoon about the importance of rural communities. As I mentioned in the Stage 1 debate, with CAP reform and agricultural support being actively discussed, there is the potential to provide greater support to crofting communities through the changes that will be made to Scotland's Rural Development Programme. And as we move from historic to area-based payments within CAP, we must ensure these opportunities are sought and found. We have heard today from across the Chamber just how vital crofting is to some of our remotest communities, and we are aware of the benefits that crofting can bring. These communities work the land and ensure its sustainability for future generations. For this to continue, crofting must be viable, and we must answer the big questions, not how laws should be drafted or redrafted, but how do we support crofts and rural areas. Earlier this month, a global meeting of La Via Campesina took place in Indonesia. It's a movement of more than 180 peasant organisations, which together boast 200 million members in more than 80 countries. The Scottish Crofting Federation is a member, as well as the newly formed Land Workers Alliance in England. Crofting has been around for generations, but in this new movement, we see a valuing of what small-scale farming can achieve and contribute. And through it, although a global movement, it brings forward a vision for Western farming, an alternative vision of what future UK agriculture could look like, one that values its huge social and cultural dimension. Large-scale farming certainly produces food, but so can small-scale, often with less environmental impact and greater community investment. So in Scotland, we must look at targeting resources, particularly to our less favoured areas, the use of agricultural support, rural development mechanisms, and greater support for housing to support and grow communities. We need increased joined-up rural development in crofting, tenant farming, land reform and farming in general. We need greater decentralisation of jobs in the economy. We have many challenges facing crofting in this country, but it's faced many we face many challenges. Crofting faces many challenges in this country, but it has faced many challenges throughout its history. And when we look at international examples, we can see that it has support and it does have a future.
Many thanks. Before I call the Minister, can I remind members that the use of electronic devices in the chamber is restricted to the delivery of speeches, and can I also ask members if they could conduct any conversations they're having out with the chamber, please. I call on Paul Wheelhouse to wind up the debate. 7 minutes, please, Minister.
Presiding Officer, I'm grateful to members for their contributions and constructive approach this afternoon, and will respond to some of the comments shortly. But first I want to reiterate my thanks to everyone involved in the Crofting Amendment Scotland Bill. It's clear there is agreement across the Chamber on a range of issues relating to this bill. Unlike the last Crofting-Bill, I'm particularly pleased Parliament has not been suspended at any part of the proceedings, or at least not so far anyway. Joking apart, we all recognise that Crofting is swamped in complex and it could also be said, I've said it myself, impenetrable legislation. To complicate that legislation further must be a last resort for any government. And that's why the Scottish Government brought forward this bill with standalone provisions to allow owner-occupier crofters to easily identify what decrofting provisions in the 1993 Act relate specifically to them. This was the most straightforward and, we believe, efficient way of dealing with the issue, while also delivering the policy intent that provisions should be similar for both owner-occupier crofters and tenant crofters, if not exactly the same because of some particular issues to do with tenancies. There are many owner-occupier crofters awaiting the solution that this bill offers. That includes those who previously received a decrofting direction and who want to relax in the knowledge that the land remains decrofted. Those who have applied to decroft land and are stuck in limbo after their application until their application can be processed by the Crofting Commission. Those who currently want to apply to decroft land for a specific purpose but know their application cannot be processed, and not least the Crofting Commission itself, which simply wants to get on with the job of regulating crofting but also needs the tools to do so. We have an opportunity today at decision time to ensure that the bill addresses these issues and treats owner-occupier crofters in a similar way to tenant crofters in relation to decrofting. I'm certainly pleased that appears to be the approach taken by all parties in this chamber, and I very much welcome that. That was the intention of the Crofting Reform Scotland Act 2010, of course, and that is what we should hopefully put right today. But as I indicated when I opened the Stage 3 debate, the ability to decroft should not be to the detriment of crofting. I will therefore ask the Commission to pick up on the point that was, I think, raised to keep the effects of decrofting both by tenant and owner-occupier crofters under review, and to ensure, particularly if it appears there's any concerns on speculation that these are founded in any way, that we can then consider options to tackle that. Members raised a number of issues today, and I will now address these in as best I can. Jane Baxter, once again, very thoughtful contribution, sadly she's not in the chamber, but very thoughtful contribution, raised the issue of Crofting Law Group remaining concerned about a number of aspects. Oh, she is back, sorry, I missed her there. And also this was picked up by Jamie McGregor, Thing and Tavish Scott, and perhaps others. I apologise if I've left them off. I recognise the concern expressed during the passage of this bill and look forward to working with the Crofting Law Group as we go forward, and other stakeholders in addressing the other issues that have been addressed. And I certainly will look forward to whatever messages come out of the conference in September. Alec Ferguson raised an issue in terms of rebuttal of concerns that the drafting approach may have other unintended consequences. I certainly again put on record my thanks to Mr Ferguson for trying to look out for my interests, and I appreciate that. The Scottish Government has, just to reassure Mr Ferguson, the Scottish Government has carefully considered whether the approach taken in the bill will have unintended consequences, and considers that the approach taken has helped to highlight issues that needed to be dealt with, such as decrofting of croft houses, which might have been overlooked had we continued to take the approach of the 2010 Act. The particular drafting that we have for the Act, as I've tried to explain, is because of the desire to try and match as best we possibly could the provisions for tenant crofting. I appreciate to some it will look unnecessarily unwieldy and perhaps complicated, but in doing it the way we have done, we've guaranteed that the provisions that are in there for owner-occupier crofters are as close as we possibly could get them to match those for tenant crofters, and to pick up the intent that Parliament had in 2010 to deliver similar treatment under the law for tenants and owner-occupier crofters. So I appreciate there are perhaps those who are purists would like to have simplified the legislation further, but we are satisfied that it does deliver as best as we possibly could similar provisions for owner-occupier crofters as those who are tenants. Alex Ferguson also raised the lack of interaction with the 1993 Act. That's probably arising from the same issue. In reality, the Act inserts new provisions into the 1993 Act, and in terms of Section 25, amends existing provisions to make the section relevant to owner-occupiers' crofters' situation. Jane Baxter also mentioned ministers need to be vigilant and monitoring. I'm not sure if she picked up when I was saying earlier on, but we have asked the Crofting Commission, as I say, to monitor the effects of legislation, and we'll look forward to hearing any feedback from them. Tavish Scott raised a very good point in terms of where the debate should really be at, which is about the quality of the beef and lamb and other produce that crofters produce. And I certainly agree the quality of beef and lamb from Crofting counties is second to none and should be celebrated. Other points that raised, I think Nigel Dawn raised the issue of retrospection, and hopefully in limiting it to those 159 crofters, owner-occupier crofters, who have already been issued with a decrofting direction, and those who are being held in abeyance in terms of those who might have missed out an opportunity for appeal. We have kept it as tightly defined as we possibly could to minimise any unintended consequences from those provisions. Jamie McGregor picked up the issue about the cost of advertising. I'm certainly happy to look at that particular issue that's been raised in recent times about the cost to crofters and see if there are any ways in which we can overcome that. But I certainly give him assurance that I will take that one forward. Claire Baker has raised some interesting points about the general thrust in terms of small units, farming units being particularly sustainable, and in terms of their low carbon footprint and so forth. And I think that's an important point she raises, and we look forward to taking forward any ideas that may come out of the kind of international movements that she mentioned. Thank you, Presiding Officer. Perhaps just in closing, I can say that, as I indicated when I indicated earlier on, in conclusion, the bill demonstrates the ability of the Scottish Parliament to address issues quickly and effectively. It represents the culmination of cross-party support for a change to legislation where that is necessary, and I thank members again across the chamber for that and for taking such a constructive approach. What we must do now is vote this bill through and then carefully consider how to progress the other matters that have been raised by members and our stakeholders. And this will require commitment from a lot of people, but I'm confident we can achieve this because we have demonstrated through this bill that we can work together when it matters most. And I'm sure that the bipartisan approach taken has been warmly welcomed by crofters themselves. Presiding Officer, in conclusion, I hope that come decision time this afternoon, members will ensure that the bill is passed for royal assent to allow owner-occupier crofters once and for all to apply to decroft their land as was intended. And once again, I would like to thank you all for taking the time to consider the proposals I have put to you. Thank you.
Many thanks, Minister. That concludes the debate on the Crofting Amendment Scotland Bill. And it's now time to move on to the next item of business. I will allow a moment for members to change seats.
Thank you. And the next item of business is Stage 3 proceedings on the Land and Buildings Transaction Tax Scotland Bill. And in dealing with the amendments, members should have the bill as amended at Stage 2, the martial list and the groupings. The division bell will sound and proceedings will be suspended for 5 minutes for the first division of the afternoon. The period of voting for the first division will be 30 seconds, and thereafter I will allow a voting period of 1 minute for the first division after a debate. Members who wish to speak in the debate on any group of amendments should press the request to speak buttons as soon as possible after I call the group. I now refer members to the martial lists of amendments, and we will make a start on them. And I call on Group 1, which is returns relating to land transactions, and I call Amendment 1 in the name of the Cabinet Secretary, grouped with Amendments 13, 23 and 27. Cabinet Secretary to move Amendment 1 and speak to all amendments in the group. John Swinney.
Presiding Officer, Amendment 13 changes Section 27 of the Bill, which allows for tax release to be claimed. The amendment is consequential to the introduction of provisions in relation to the taxation of leases at Stage 2. In a transaction involving a lease, it is possible that when the transaction first takes place, there is no requirement to notify the tax authority, and therefore no land transaction return is made. Later, however, if the rent is increased or the period of the lease is extended, the lease may become notifiable and also possibly taxable. The effect of this amendment is to allow the tenant at that point to claim a relief in a return other than a land transaction return. Amendments 1, 23 and 27 are minor amendments that broaden out references to land transaction return in sections 248 and 56 respectively, so that the sections relate to other returns as well. I move Amendment 1.
Thank you, Cabinet Secretary. And as no one has requested to speak, would you wind up now as well, please?
No further comments, President Officer.
Thank you. So the question is that Amendment 1 be agreed to. Are we all agreed?
Agreed.
We are. So we now move to Group 2, which is minor change. It's consequential on Stage 2 and other technical amendments. And I call Amendment 2 in the name of the Cabinet Secretary, grouped with Amendments 7, 14, 15, 31, 36, 40, 41, 42, 43, 44, 45, 46 and 67. Cabinet Secretary to move Amendment 2 and speak to all amendments in the group, please.
Presiding Officer, this group of amendments covers three areas. Some amendments are consequential amendments to the bill flowing from the addition of Schedule 18A on leases at Stage 2. Some correct typographical errors in the bill and others make minor drafting improvements. There are no other changes of substance involved in this grouping of amendments and I therefore move Amendment 2.
Thank you. Cabinet Secretary, if you'd like to wind up again, please.
No comments.
Thank you. So the question is that Amendment 2 be agreed to. Are we all agreed? Yes. We are. So we'll now move to Group 3, which is chargeable interest. And I call on Amendment 3 in the name of Cabinet Secretary, grouped with Amendments 4 and 5. Cabinet Secretary to move Amendment 3 and speak to all amendments in the group.
Presiding Officer, these three amendments to Section 5, which deal with exempt interests, are minor consequential drafting amendments resulting from changes made to Section 4 during Stage 2. The phrase interest or right, which occurs on 3 occasions within Section 5 at subparagraphs 2, 4A and 4B, refers back to what Section 4 used to say, namely interest, right or power in or over land. Now that Section 4 uses the phrase real right or other interest in or over land, Section 5 should be amended accordingly to reflect this. And I move Amendment 3.
Thank you. Now call on Gavin Brown.
Thank you, Deputy Presiding Officer. These amendments flow from a change at Stage 2 to the definition of a chargeable interest. This change from an interest or right to a real right or other interest in or over land. There's no doubt in my mind that these amendments are an improvement, as indeed was the amendment at Stage 2. But I think there is still some doubt about the use of the expression other interest in or over land. Indeed, one of the sources quoted previously by the Cabinet Secretary at Stage 2 is adamant that that definition still lacks clarity. Now, in the absence of a better definition today, we will be supporting these three amendments, but I just wonder if the Cabinet Secretary would assure Parliament that the door on this is not entirely closed if further information comes to light from the experts that he has previously quoted.
Thank you. Cabinet Secretary, wind up, please.
Presiding Officer, clearly as part of the exercise in formulating this bill, the Government has sourced well-informed advice about enabling us to provide the clearest possible legislation in this context. I'm satisfied that the provisions that we strengthened at Stage 2 and which are reflected in the amendments that I have just moved put us in a position to have the best amount of clarity we can in a complex area of activity. Of course, if we see with the passage of time and the utilisation of this legislation any deficiencies in relation to the application and interpretation of that wording, then of course the Government will reflect on these points. But I'm certainly satisfied that the provisions in front of Parliament today are appropriate and worthy of Parliament's support.
Thank you very much. So the question is that Amendment 3 be agreed to. Are we all agreed? Yes. We are. Thank you. I now call Amendment 4 in the name of Cabinet Secretary. Already debated with Amendment 3. Cabinet Secretary to move formally.
Formally moved.
Thank you. So the question is that Amendment 4 be agreed to. Are we all agreed? Yes. We are. Thank you. I now call Amendment 5 in the name of the Cabinet Secretary. Already debated with Amendment 3. Cabinet Secretary to move formally.
Moved, Convener.
Thank you. And that question is that Amendment 5 be agreed to. Are we all agreed? Yes. We are. Thank you very much. So that concludes that section. We'll now move to Group 4, which is leases. And I call Amendment 6 in the name of the Cabinet Secretary. Grouped Amendments 8, 10, 11, 12, 16, 17, 18, 19, 20, 21, 22, 25, 29, 32, 35, 37, 38, 39, 47, 48, 49, 50, 51, 52, 53, 54, 55, 56, 57, 58, 59, 60, 61, 62, 63, 64, 65, 66 and 68. Cabinet Secretary to move Amendment 6 and speak to all amendments in the group, please.
First of all, Presiding Officer, can I apologise for the length of speeches you have to make in chairing this debate. This group of amendments are all to do with the tax treatment of leases and comprises the list of amendments the Deputy Presiding Officer has read out. Members will be relieved to hear that I don't intend to speak to every amendment in this group. Instead, I will highlight some of the more important provisions that are covered. Schedule 18A runs to over 15 pages and as members will recall, it was introduced by amendment at stage 2. The length of this schedule demonstrates the complexities and technicalities that arise when seeking to apply taxation fairly and reasonably to the range of commercial situations that arise perfectly legitimately under property law. I indicated when speaking at the Finance Committee Stage 2 session on the 5th of June that a further meeting between my officials and the Non-Residential Leases Working Group would take place on the 11th of June, and this might necessitate further refining amendments being made to the leases schedule. A number of the amendments before the Chamber today are as a direct result of the constructive dialogue that took place at the meeting on the 11th of June. For example, Amendment 55 deletes paragraph 13 of Schedule 18A. Paragraph 13 provides that any payment made before a lease is granted is treated not as rent but as a premium and taxed accordingly. Deleting this paragraph will remove an unnecessary presumption and mean that a payment made before the grant of a lease may be treated as rent if, in fact, it is rent, or as a premium, depending on the nature of the payment. Other amendments that flow from the discussions between my officials and the working group include Amendment 6, which ensures that the variation of a lease is not treated as the deemed grant of a new lease, except where paragraph 31 of Schedule 18A applies, and Amendment 65, which removes paragraph 26 of Schedule 18A. That paragraph would have covered something that doesn't actually happen in commercial practice. I also indicated at the Finance Committee meeting that I would bring forward at stage 3 further technical amendments to the bill. These are mainly amendments to earlier parts of the bill that were considered at the committee's stage 2 session on the 29th of May. Many of the amendments in this group have been lodged to meet the commitment that I gave. For example, Amendment 21 is a consequential amendment to Section 40, flowing from the addition of Schedule 18A at Stage 2. The amendment will mean that where a tax return is made under paragraphs 10, 11, 21, 23 or 32 of Schedule 18A, then the tax due or additional tax due must be paid at the same time as the return. Other amendments that fall into this technical category are Amendments 10 and 20. Amendment 10 inserts a reference to paragraph 3 of Schedule 18A into Section 24, so that someone reading Section 24 will be alerted to the fact that the tax rates and tax bands for rent will be set not under that section but under Schedule 18A. Amendment 20 amends Section 39 so that it will now refer to the various paragraphs in Schedule 18A under which returns are made and in relation to which there is a power to specify a different period for making the return. Finally, perhaps the key amendment out of these 40 amendments is Amendment 25, which adds a power to amend Schedule 18A by regulations. Amendment 29 ensures that any regulations made will be subject to the affirmative procedure. In light of the complexity of Schedule 18A, I consider it prudent for ministers to take a power which will enable them to amend this schedule by secondary legislation. This will provide a degree of flexibility in terms of Scottish ministers being able to respond quickly and effectively to changing commercial situations. There is further detail I can provide in response to issues raised by members, but in the meantime I move Amendment 6.
Many thanks, and since no member has asked to speak, Cabinet Secretary, if you have anything to say in winding up?
No further remarks, Convener.
Thank you. In that case, we'll move to the question, and the question is that Amendment 6 be agreed to. Are we all agreed? Yes. Thank you very much. I now call Amendment 7 in the name of the Cabinet Secretary, already debated with Amendment 2. Cabinet Secretary to move formally.
Moved, Presiding Officer.
And so the question is that Amendment 7 be agreed to. Are we all agreed? Yes. We are. I now call Amendment 8 in the name of the Cabinet Secretary, already debated with Amendment 6. Cabinet Secretary to move formally.
Moved, Presiding Officer.
Many thanks. And so that question is that Amendment 8 be agreed to. Are we all agreed? Yes. We are. So we now move to Group 5, Procedure for Orders Setting Rates and Bans. And I call Amendment 9 in the name of Gavin Brown in a group on its own. Gavin Brown to move and speak to Amendment 9, please. Mr. Brown.
Thank you, Deputy Presiding Officer. The key question to be answered here is, does the Scottish
Would you just move your microphone a little bit more towards you, so that we can hear?
The key question to be asked here, to be answered here, Deputy Presiding Officer, is, does the Scottish Government believe in evidence-based policy? It's our job, in my view, to remove as many layers of uncertainty from the business community that we possibly can. Amendment 9 seeks to do that by ensuring that at least 12 months' notice is given for the rates and thresholds of the tax on non-residential property. The Government's original plan was to publish those rates and thresholds in September 2014 for application in April 2015. But then the Finance Committee took evidence, and the business community right across the board were crystal clear and robust in their view that they needed notice of the rates and thresholds earlier than that. Some said 12 months, some said 18 months, some said quite literally now. But they were resolute that it had to be sooner than what the Government was proposing. We heard evidence from the Scottish Building Federation, the Scottish Property Federation, Homes for Scotland, CBI Scotland, ICAS, and many others, all of whom took the same view. The Cabinet Secretary then announced that he was considering publishing later because, in his view, the evidence was mixed. In my view, Deputy Presiding Officer, the evidence was unanimous, and the only person arguing that it ought to be later was the Cabinet Secretary himself. When investors prepare their project assessments, Deputy Presiding Officer, there is a question mark hanging over LBTT at the moment. They are unable to put a rate towards it, and that leaves uncertainty. If one investor is attempting to invest in the northwest of England, then they have a clear number they can put against stamp duty. If that same investor wishes to invest in Scotland post-April 2015, that has to remain blank at the moment. And as we all know, investors do not like question marks. I note the Scottish Government response to the Stage 1 Committee report, which said this: the Scottish Government will consider the evidence provided to the committee regarding the timing of the publication of the proposed LBT rates and bans for both residential and commercial property transactions. I asked the Government to consider that evidence. I asked the governments to accept this amendment to give at least some certainty and to remove one layer of uncertainty away from the business community, and I therefore move Amendment 9. Thank you.
Many thanks. I now call on Ken McIntosh.
I want to speak, if I may, in support of Amendment 9 from Gavin Brown. I will accept the Cabinet Secretary has spoken against this in the past. There is a genuine concern about gaming the system, about property deals being brought forward with advanced knowledge to reduce tax. But the prospect of such activity taking place on any substantive scale has to be balanced against the desire of most respectable Scottish businesses simply to have certainty and confidence in the system. In fact, it's notable that nearly all those who gave evidence were united in this point. Brodie, CBI Scotland, the Chartered Institute of Taxation, COSLA, ICAS, the Scottish Property Federation, all of them expressed concern that the actual rates will not be known. Now, the fact that the date around which the Cabinet Secretary's decision seems to pivot is a political one, the date of the referendum in September 2014, adds to the worry that he's making a political decision rather than a business-orientated one. And it's driven by the needs of, not one driven by the needs of the public finances. Not announcing a decision until after 2014, September 2014, sounds like he's picking a day to bury bad news rather than providing stability and certainty for the Scottish property market. And I support amendment in Gavin Brown's name.
Thanks. Now call on Willie Rennie.
I too support Gavin Brown's, I think, eminently sensible amendment. I think we're not suggesting that on every single year that a year's notice should be given for any changes. We're suggesting that in the first year, so that greater certainty can be provided for the sector. The construction sector has gone through, as we know, some significant difficulties in recent years, and I think we try to reduce the uncertainty that may be caused through this as far as we can and as far as is possible. So I think it's eminently sensible what Gavin Brown has suggested. As the Finance Secretary said this morning, there's only 5 months of a difference between what he's suggesting and what Gavin Brown's suggesting. I don't think that's a gap that should be unbridgeable, and I would suggest to the Finance Secretary that he listens to the evidence that has been set out and agrees with Gavin Brown. Thank you.
Thanks, and I now call on Patrick Harvey.
Thank you, Deputy Presiding Officer. I hadn't been intending to speak in this grouping, but I was a little disappointed at the level of support across the Chamber for this amendment. In particular, I would like to challenge the use of the phrase evidence-based policy. We generally use that phrase in relation to policy that should be informed by objective data, scientific evidence. We don't use it in relation to the assertion of want. And the evidence that Gavin Brown referred to in his comments were simply an expression of the wishes and the self-interest of the particular witnesses who gave evidence on this question. This is not an area where we have objective data. It's an area where we have the assertion of the self-interest of the business community. And I do think that it's worth making the distinction between the two.
Thank you very much. And I now call on the Cabinet Secretary.
Presiding Officer, this is an issue that has certainly attracted commentary, and Gavin Brown has set out the opinions of different business organisations and companies within the private sector, and he's perfectly able to do that, and that was all stated on the record. And the contribution of Ken McIntosh reinforced the points that Mr Brown raised and suggested some political motivation on my part for the timing that I had originally suggested as being appropriate for the setting of tax rates and tax bans. And none of the contributors made any passing reference to the fact, and this is where Mr McIntosh is just wholly and completely misguided in what he's saying, is that the motivation for me in identifying the setting of these tax rates in September of 2014 is because of the relationship between the setting of tax rates and the implications for the Scottish Government's budget. And I wouldn't have thought that was a connection I really had to make in Parliament, given that Parliament requires of me to present a budget in September of each year. And Parliament will have to become accustomed in the years going forward to an increasing relationship between the decisions that we take on tax and the relationship between those decisions and public expenditure and the decisions that we make. So the relevance, the connection between setting our tax rates and tax bans and the budget that I propose to Parliament is an inextricable link. I cannot go around setting tax rates at a different stage in the financial year to the setting of the budget, because I might set tax rates in a particular context, in the context that Mr Brown is suggesting here, and I may find myself dealing with a different financial circumstance as it emerges in a budget process within the consideration by Parliament. Of course, I'll give way.
Malcolm Chisholm.
I thank him for his very interesting explanation, but how does that explanation fit with the commitment that this tax would be basically revenue neutral? I'm struggling to see how that is consistent with the idea that it might change with the general public expenditure situation.
Well, my point is that we should link in this Parliament clearly and simply the decisions that we make about tax rates to the setting of our budget and the commitments that we make that follow from that. Because, for example, the block grant adjustment will apply from April 2015, and we need to know the context and the circumstances within which we are taking those decisions. Now, in the call for evidence that the Finance Committee brought forward, the Finance Committee also received representations indicating that in the residential property sector there was an argument in favour of not setting the tax rates in September, as I suggest, but setting it much closer to the start of the financial year to avoid any market distortions that might take place. If I was to listen to the evidence on that point, I would be delaying setting of the tax rates and tax bans until much closer to the start of the financial year, which in my opinion is not able to be justified or sustained. So I think it's important that we establish the connection between the setting of tax rates and tax bans, the formulation of the budget, and on balance, having listened carefully to the points of view put forward by different interested parties, my recommendation would be that we should set the tax rates and bans for all transactions as part of the budget process in 2014. and as a consequence I would encourage Parliament not to support the amendments put forward by Mr Brown.
Thank you. So Gavin Brown to wind up and press to withdraw your amendment, please, Mr Brown.
Thank you, Deputy Presiding Officer. I'm grateful for contributions from all speakers. I'm slightly surprised at Patrick Harvey's definition of evidence, that unless it is scientific objective data, it cannot be classed as evidence. What do people do week in, week out at every committee in this Parliament? They submit written evidence and they give oral evidence. To suggest that none of that, in his rather narrow view, is not evidence is something I find a little surprising. But dealing with, I think, the substantive, no, I won't give way on that point. The Cabinet Secretary, I think, has given a fairly weak reason for not bringing forward the setting of the dates. It cannot possibly be at any other time of the year other than September 2014, when I bring forward that draft budget. My amendment says it has to be at least 12 months. It could be earlier than that if he so wishes. He could bring it forward in September 2013 if he so wishes, setting out what he has in mind for thresholds and rates. I repeat again, Deputy Presiding Officer, he said very clearly that he would consider the evidence. He would listen to representations from the industry, and every single representative, when it came down to commercial, which is what this amendment was about, said you should be doing it earlier. In our view, sure.
I thank the member for giving way. I wonder if he would accept that really all the evidence we had, all the witnesses we had, were business representatives at the committee. We did not hear from the normal residents or the constituents of the country, and we've got to act on their behalf, not just on behalf of business.
I think the idea as a committee, you decide, and he's the deputy convener of that committee, incidentally, you decide who is most likely to represent the stakeholders that you're trying to consult, and you invite them specifically to give written and oral evidence, and of course it's unlimited who can give written evidence. The idea that you ignore the evidence presented in front of you just in case there are other people that you've not quite heard from yet, and you're going to prefer what might be their view, I find a little bit surprising, and it almost kind of calls into question why you bother having committees if you're not going to take into account the evidence that they give. Deputy Presiding Officer, we should use all the levers at our disposal to help business in this country, not just some of the levers at our disposal and the ones that suit us. I therefore press Amendment 9.
Thank you very much. And so the question is that Amendment 9 be agreed to. Are we all agreed? We are not agreed, and there will therefore be a division. And as this is the first division of the stage one, of the stage, I suspend for 5 minutes now. So we will now proceed with the division on Amendment 9, and this is a 30-second division. Members should cast their votes now, please. Thank you. And the result of the vote on amendment number 9 in the name of Gavin Brown is yes 50, no 66. There were no abstentions. The amendment is therefore not agreed. I now call amendments 10, 11, 12 and 13, all in the name of the Cabinet Secretary and all previously debated, and invite the Cabinet Secretary to move amendments 10 to 13 en bloc.
Moved en bloc, President.
And does any member object to a single question being put on amendments 10 to 13? And as no member has objected, the question is that amendments 10 to 13 are agreed. Are we all agreed? Yes. Thank you. We now move to Group 6, which is the Energy Performance Variation. I call Amendment 69 in the name of Patrick Harvey, grouped with Amendments 73 and 74. Mr Harvey to move Amendment 69 and speak to all amendments in the group, please.
Thank you, Deputy Presiding Officer. These amendments taken together rehearse a debate which was taken forward by Malcolm Chisholm at Stage 2 in the proposal to have variations in the level of tax related to energy efficiency as an incentive for property owners to invest in the energy performance of their property, not in order that they pay a lower level of tax, but in order that they can secure a better price on their property because the buyer would pay a lower level of tax. I have changed these amendments to some extent to take account of some of the arguments that were made at Stage 2, including by the Cabinet Secretary, and I do think it's worth returning to the arguments in general, and hopefully the Government, even if it remains unpersuaded by the amendments, hopefully the Government will use the opportunity of this discussion to indicate how else they might seek to secure the same objectives. The basic case in favour of improving the energy performance of our building stock, reducing overall energy waste and energy demand has, I think, been well made over many years. And in relation to housing, we've taken action in the social rented sector. We've taken action in relation to building standards. And we've put some schemes of support into place to allow homeowners to access advice and support with particular measures. It is an additional tool that we're debating today, the idea of putting an additional mechanism in place that would give incentives for some properties to be brought up to standard. Would the member give way? Yes, indeed.
John Mason.
I thank the member for giving way. I mean, I agree with what he's trying to do, but does he feel that this is the most effective way of doing it? There is a cost to this, and would it not be better to use that either to maybe reduce council tax or to give a direct grant for energy efficiency?
Patrick Harvey.
One of my favourites are Humphrey objections. But is this the best way, Minister? I'm sure that there will be objections that Mr Mason will have made in Stage 2, which he'd like to return to. He made the argument, for example, that this will cover only a small proportion of properties. The building standards, the measures that we take to improve building standards, also only apply to a small proportion of properties in any 1 year. And yet, we think it's an important measure, one of the many tools in the box to improve standards. He mentioned, I think, at Stage 2, the argument that I think what was called £1 million mansions might benefit, or rather the owners of them. And I don't find that a convincing objection either. These are the very properties which often cost the most to bring up to standard in terms of energy performance. So in order to secure a better price on an expensive property like that, an owner would have to pay more in order to achieve that. There is also a question of the context of this bill as a whole, which the government intends to make a more progressive form of taxation than the current one. And so the owners of such properties would already be paying more under the government's proposals. This would be a small variation in order to give them an incentive to look at the energy performance. Are we tight for time, Deputy Presiding Officer?
Time for an intervention if you want.
Will you not accept that almost the opposite argument to what you're making could apply, so that the effect of what you're suggesting could result in a situation where very poor people live and are trapped in very poor and very poorly insulated houses?
Not at all. I don't accept that argument at all, because as the government is at pains to stress, and as I personally welcome, low-value properties will be exempt from this tax altogether. So it simply won't come into play there. And those are very often the people who will get the most support from the various government schemes of energy efficiency, advice and support, and where an incentive like this is less relevant. The government has made the argument in favour of simplicity as opposed to complexity, and that's one of the reasons why I've changed aspects of the amendment that was debated at stage 2. This is no longer a requirement on government to introduce such variations. It is enabling government to introduce variations, not with a 12-month time limit to ensure that they have to get it done before they get it right. This will give them the time to develop a system of variation which fits into the wider context of the way they would like this taxation to work. And finally, the objection from the Cabinet Secretary at stage 2 about tenement dwellers, the need to secure neighbour agreement if improvements are required across a whole building in order to achieve the incentive, the objective intended. And as a tenement dweller, I do take that very seriously, and that's why I've introduced an additional line in the amendment to enable the government to apply this measure differently in relation to different building categories. And I think that hopefully should allow the flexibility that the government would need to ensure that the appropriate effect is had on all building categories. I do hope that there is a degree of support for this measure. If the real objection, Deputy Presiding Officer, is that it's the wrong way to achieve the right aim, then I would like to hear a clear commitment from the Cabinet Secretary on the measures he does intend to take to drive up energy performance in the private sector as a whole, and an indication of when, for example, he will introduce requirements on the point of sale or let of of privately owned properties, because it's not enough simply to offer a few subsidised measures on a means-tested basis as presently. The government won't meet the CO2 reductions targets that it must from the housing sector unless we're proactive at pushing up energy efficiency right across the housing stock. And I move Amendment 69, Deputy Presiding Officer.
Thank you very much. And I now call on Malcolm Chisholm.
Presiding Officer, I thank Patrick Harvey for introducing this amendment. I think he's listened very carefully to the debate that took place in committee. He's realised there is a great deal of objection to this on the government side, and that's why he has modified the position put forward in amendment, changing must to may. And I think that's a very significant change, because it means it's a permissive amendment with no time limit to it, so the government in a sense can be unconvinced at this stage but still think it is worth putting in the bill, because who knows, in a few years' time there may be other factors and other considerations, and the possibility will be there of introducing this amendment at that point. Now, John Mason said, is this the best way? I think that's the wrong way of thinking about this crucial matter. There is not one way of dealing with this problem. There are many ways, and this could be one part of the suite of measures to address the problem of energy inefficiency in homes. And remember, the two biggest challenges for us in terms of climate change are transport, which we're not discussing today, and existing homes, which we are discussing. And this is basically a measure to try and deal with the energy efficiency, or help deal with the energy inefficiency of existing homes. John Mason also says there is a cost to this. Well, in fact, there's not. If you read the amendment, it is designed in such a way as to be revenue neutral. I don't think we'll be allowed to make a long enough speech at this stage to explain how that operates, although John Mason may well be going to ask me that very question.
John Mason, briefly, please.
Would you accept that although overall it's revenue neutral, if you're going to raise a bit more tax off one person and spend it on somebody else, there is a cost?
Well, clearly it will affect some people in energy inefficient homes, but as Patrick Harvey said, that will not be people on homes of a modest amount because of the commitments the Cabinet Secretary has already given about the starting point for the tax. Now, another argument that was used in committee and may well be used again is that energy efficiency is not uppermost in people's minds when they buy a house. That is actually an argument in favour of the amendment, because it will put that issue into people's minds when they buy a house, and that is what we need. We should all be thinking of this when we buy our houses, and indeed when we heat our houses every day of the year, or every day as it seems at present anyway. Now, it seems to me that this would be to the advantage, final point, to the advantage of both sellers and buyers. Some people say how it would be to the advantage of sellers. Well, they would be in a better position for selling their house. They would have an advantage in terms of selling it more quickly, and they would also perhaps be likely to get slightly more money for it than they would otherwise get. From the buyer's point of view, of course, the advantage is obvious in paying less of the new tax. So I know the government is very sceptical about this. I was very sceptical when this proposal was first put to me, but the more I have thought about it, the more I have become convinced that it is one and only one of several measures that are needed to deal with the urgent issue of the energy inefficiency of all homes, but particularly of existing homes.
Thank you very much. Now, Colin John Mason.
Thank you, Presiding Officer. I mean, as I said in my intervention, I do have a lot of sympathy for the aim of this and what Patrick Harvey is trying to do. And I think at committee, although Malcolm Chisholm says he kind of drifted from being sceptical to being positive, I think I went the other way after we had listened to the evidence, which I have to say was not very convincing at all. I think at first several of us did think that something like this might be feasible, but then when we looked at it in more detail, it became apparent that it was a very blunt instrument. As I think I've tried to point out already, there is of course a cost to it, even if overall it was revenue neutral. And if we're going to raise a bit more tax, then the question still is, with these resources, what is the best thing we can do with them? And I'm far from being convinced that the best thing to do is to give these kind of incentives through LBTT, when perhaps we could be doing better things by a grant, which would directly help people to improve their homes, or a council tax reduction, which would immediately or the following year give them an incentive. Because this kind of amendment only helps people if the house is sold or purchased. So if a house is not sold or purchased, there is no incentive whatsoever. And Malcolm Chisholm says this is a way of raising awareness. Well, I really think there are other ways of raising awareness, and perhaps better ways. But I think the reason against this that is strongest for me is that a lot of my constituents and others are buying houses under £100,000. Now, that means there is no LBTT in the future, and therefore there is no incentive. So this amendment would help the better off in the bigger houses, and it would do nothing for the poorer people and the less well off in the smaller houses. And for me, that is completely convincing that this is not the way to use the limited resources that we have. Thank you.
Thanks very much. Now, Colin Willie-Rennie.
John Mason's last point was interesting, because he's implying that we're only really interested in carbon emissions if they're able to support people who have got smaller houses and less expensive houses. I think that's the opposite. I think we should be looking to tackle climate change wherever the emissions come from. That, to me, is the most important aspect of what we're trying to do with climate change, because some of the biggest houses actually emit some of the greatest amounts of carbon. So I'm in support of Patrick Harvey's amendment, because I think it's a big opportunity to seek a change in the way that we view buildings. At a time when people are buying and selling properties, they shouldn't just be thinking about the value of the property, but also the sustainable long-term future of that property and how much it costs for them to run. And actually part of that should be how much they're paying in the tax. So I think it's a valuable way to proceed. And just because it doesn't deal with every single house in the country, because not every single house in the country has been bought and sold at once, doesn't mean it's not a good thing to proceed with. It seems to be an eminently sensible way to proceed, to focus people's minds, to try and get them to think about energy efficiency in all their properties all the time, just in case they are prepared to sell their property at some point in the future. And just because this has been proposed through this bill doesn't prevent other measures coming forward for other bills as well. There can be a variety of different measures that can be introduced by the government, and this does not prevent them from doing so. So I support Patrick Harvey's amendment, and I would urge the government to support it too.
Much. Ken McIntosh.
Thank you, Presiding Officer. And I too want to speak in support of Patrick Harvey's amendment, which was very similar to that proposed by Malcolm Chisholm at stage 2. I think the key reason is clearly, the key motivation is clearly to encourage the uptake of energy efficiency measures and to help Scotland, and for that matter, to help the Scottish Government meet its carbon reduction targets. Now, I accept many of the arguments at stage 2 were evenly balanced, and from the Government there is a desire not to introduce new tax relief, but to remove tax reliefs from the stamp duty system and not to replace them in the LBTT system. And broadly, we do support that approach. But the Government itself did not think that should be applied absolutely across the board. In its own consultation on this bill, the Government said the replacement of SDLT stamp duty with an LBTT also offers the opportunity to support key Scottish Government priorities through incentivisation. So that was the Government's own consultation, suggesting that we could use it to incentivise government priorities. And clearly this is a priority to try and make carbon, to meet our carbon emission targets. And the Government further, if I refer to the Climate Change Scotland Act, this is another government bill which requires local authorities to establish a scheme for reducing the amounts which persons are liable to pay in respect of council tax, where improvements are made to the energy efficiency of chargeable dwellings. So in other words, the Government acknowledge that there is a way for taxation to be used to establish better energy efficiency. So why not do so in the case of LBTT? I would encourage the Government to support Patrick Harvey's amendment.
Thank you very much. And as we're nearing the agreed time limit, I'm prepared to exercise my power under Rule 9.8.4ac to allow the debate on this group to continue beyond the limit in order to avoid the debate being unreasonably curtailed. Cabinet Secretary.
Presiding Officer, can I thank Mr Harvey for bringing forward these amendments? He and I have form in parliamentary debates on issues around energy efficiency and home insulation, so hopefully we might be able to make some progress today where we might not have managed it in the past. Amendments 69, 73 and 74 are intended to introduce a regulation-making power to the bill that allows for the amount of LBTT to be paid for a residential property transaction to vary depending on the energy efficiency rating for the house. Although the amendments do not provide for it, presumably there would have to be some sort of benchmark against which the energy rating of each house would have to be assessed in order to calculate the tax due. That benchmark might be, for example, the average energy rating for all housing in Scotland. This proposal has been advanced by the Existing Homes Alliance, and my officials have met with the proposers to consider the issues. The Government is entirely supportive of steps to improve the energy efficiency of Scotland's housing stocks and has taken a number of steps to do so. While it is important to examine all legislative instruments to determine if any measures can be taken forward, it is vital also to assess what impact any proposed measures might actually have. In this bill, there is a balance to be struck between the need for a simple, certain and efficient tax system and the likely improvements to energy efficiency that would flow from the change proposed to calculating the tax liability on the sale of residential property. Far from providing more simplicity and certainty, these amendments would actually add complexity and uncertainty to the tax. No house buyer would be in a position where they know at the outset how much tax would be payable for a house of a particular value. Additional information would be required in order to calculate the liability, and this information may change over time. Following the submission of a tax return, the energy rating for every house sale would have to be verified by Revenue Scotland to ensure that the tax was calculated accurately. This requirement would add considerably to the administrative burden of Revenue Scotland. Aside from the administrative complexity, the proposal would have no effect whatsoever for housing in the nil rate band of the tax. In 2011, there were 1.9 million privately owned dwellings in Scotland and 70,000 sales, representing 3.7% of the market. The Land and Buildings Transaction Tax consultation paper set out two scenarios to illustrate how a progressive tax might operate in the residential property market. In scenario 1, 70% of the housing market is excluded from the tax. This means that the tax would apply to only 1.1% of the existing stock in any given year. This equates to 21,000 properties. Mr Rennie encouraged us to support this amendment on the basis that it doesn't deal with every single house. Well, we've got a long way to go from 1.1% to covering every single house. Now, even if these figures were doubled to reflect a more active property market, Land and Buildings Transaction Tax does not appear to me to represent an effective mechanism to influence the energy efficiency of the whole housing stock. The proposal would also have a number of disproportionate effects in the housing market. Firstly, under the proposal, and this has been commented upon already, the least energy efficient properties would arguably be less attractive to buyers as they would incur more tax. Owners of flats would find it very difficult to secure the agreement of other owners to undertaking any form of repairs and improvements. In my view, it would be unfair to penalise the owners and buyers of flats who would like to increase their EPC rating but find they can't because of a lack of agreement. And flats comprise around 4 in 10 of Scotland's housing stock and 74% of the housing stock in the city of Glasgow. Secondly, the scheme is intended to apply... yes.
Thank you. Thank the Cabinet Secretary for giving way. Does he not accept that I have taken account of that concern in the changes to this amendment? And surely it's not beyond the wit of himself or his colleagues in the civil service to come up with variations on this measure which would take account of those different building categories.
Cabinet Secretary.
I appreciate that point, but I think that perhaps reinforces the point I've just made to Parliament about complexity, because we would then have to design a whole variety of different reliefs and exemptions to deal with different housing structures, all of which would have to be verified by Revenue Scotland to guarantee that the appropriate tax had been paid. So I think we would simply reinforce the concern about complexity to which I have already referred. The scheme is intended to apply to every subsequent transaction of the same house, so tax benefit would therefore continue to accrue on houses where homeowners are undertaking no investment in energy efficiency measures. However, another owner may have implemented a number of improvements, costing, say, £5,000 to achieve a standard assessment procedure or SAP rating of, say, 60, but more tax would still be due on that property than if the scheme didn't exist. A rating of 60 can be very challenging for properties, often in our island and highland communities, using certain types of fuel such as LPG. Finally, and more fundamentally, it is not clear that the proposal that underpins these amendments would have a direct positive impact on the energy efficiency of Scotland's housing stock. It is the seller of the house that undertakes energy efficiency measures, but the buyer of the house that incurs the tax on the transaction. But because of that disconnect, the proposal would provide no direct incentive for additional energy efficiency measures to be introduced to Scotland's housing stock by the people who actually occupy the properties. Now, two further points that I'd like to make in relation to this.
Briefly, Chisholm, please, if you would.
President. Malcolm Chisholm highlighted the fact that the amendments refer to may rather than must. I would point out to Parliament that at section 27(3) of the bill, as it stands, it provides for Scottish ministers may by order modify this Act so as to add a relief. So if the Government wanted to add a relief in this respect, it has providing Parliament agrees to this, it will have that power already. And Ken McIntosh sort of kind of inferred that he criticised the Government for even asking the question in the consultation paper, were there energy efficiency measures that we could take? We asked that question to try to design measures that were able to have an impact. We haven't been able to find that here. That will not stop us looking for other measures in terms of our capital programme to put energy efficiency measures into, well, as we have done since 2008, 540,000 Scottish houses have received over 620,000 free or subsidised cavity wall or loft insulation measures. We'll continue to do that. We'll also continue to encourage local authorities to take up council tax discount schemes, which strike me as a more effective way of doing that, which was provided for already in the Climate Change Act. So on the basis of those arguments, whilst although my arguments here have run contrary to the proposals put forward by Patrick Harvie, I would make the commitment to Parliament that the Government is working to improve the energy efficiency of Scotland's housing stock, and we will find other ways of ensuring effective measures can be taken in that respect.
Many thanks. And as we are now pressed for time, Patrick Harvie, to wind up and press to withdraw your amendment briefly, please.
Thank you. I have to admit I'm disappointed that the Cabinet Secretary didn't specify what measures he will be bringing forward if this is the wrong one. It seems to me that measures to achieve dramatic improvements in the energy performance of our housing stock can be achieved through directly paying for them, subsidising measures, or by incentives such as this one, or by compulsion. I've spent long and hard years persuading the government to do more on subsidised measures, and they have come some way over that time. We do need to start putting in place real incentives, and it may be necessary in the longer term to look at compulsion, but if we want to avoid that, we need to get all the incentives in place that we can. The Cabinet Secretary is still concerned that this will benefit buyers, not sellers. Sellers having to invest and buyers gaining the benefit. And I think that was answered best by Malcolm Chisholm, I think, who was the first member in this discussion to recognise that this is a bit of a trigger idea. It's to encourage people. Let's remember that buyers and sellers are the same people. If you buy a property, you're likely to sell it on at some point. This is about encouraging people to think about that transaction in relation to energy performance and what they can do at that time to address it. I would like to respond to all the members who've spoken, but I'm aware the Deputy Presiding Officer has asked me to be brief, so can I simply put on record my gratitude for those members who've spoken in support. And in relation to the Cabinet Secretary's disagreement on the basis that this doesn't deal with every single home and that we've got a long way to go before we can deal with every single home, that is absolutely the right, correct argument. But the answer has to be, if this isn't the best way, what is? And can I, in pressing Amendment 69 to the vote, but anticipating that it will fall, can I urge the Cabinet Secretary to return to the Chamber after the summer recess with clear proposals on how else this important objective will be secured?
Many thanks. And the question is that Amendment 69 be agreed to. Are we all agreed? There will therefore be a 1-minute division. Please vote now. The result of the vote on amendment number 69 in the name of Patrick Harvie is yes 40, no 77, and the amendment is therefore not agreed. Now move to Group 7, which is relief for transactions involving transfer of rights, and I call Amendment 70 in the name of Gavin Brown, grouped with Amendment 72. Mr Brown, to move Amendment 70 and speak to both amendments in the group, please.
Thank you, Deputy Presiding Officer. The objective here is to make the business environment as competitive as possible. These amendments specifically relate to subsale relief and forward funding. This, in my view, is a potentially important relief. I feel we ought to reject the aspects which are abused in relation to stamp duty, but retain the aspects which help our economy, especially at a time when bank lending is reduced and forward funding becomes more important, at least for now, within our economy. Amendment 70 is mandatory in the sense that it forces the government to consult and it forces them to bring in a relief, but it does give them a fairly wide degree of flexibility on precisely what ought to be encapsulated into that relief to produce a targeted approach to subsale relief. Amendment 72 simply follows on from that, meaning that any regulations they do bring forward must be affirmative. In taking evidence on the committee, Deputy Presiding Officer, suggestions were made that you could reduce the tax avoidance from making them formally claim for the relief, allowing it only when there are no other reliefs being claimed at the same time, and also having a focused, targeted range of options, particularly in relation to house building, to part exchange, to certain rural and farming transactions, and to forward funding as a whole. The Scottish Government response to the committee report said the Government wants to ensure that forward funding arrangements are not subject to double taxation under LBTT and will work with key stakeholders to achieve this objective. I think these amendments make that objective more likely, and I therefore move Amendment 70.
Many thanks. Now Colin Ken McIntosh.
Thank you, Presiding Officer. And although we have some sympathy for Gavin Brown's amendments, I would move against Gavin Brown on this issue. We know that SDLT is susceptible to a number of avoidance measures, and the evidence suggests that the existing subsales relief, which involve the transfer of property to a third party, is a significant avenue for tax avoidance. Now, two of the chief aims of this legislation were to simplify the SDLT and to reduce the high incidence of tax avoidance. And I appreciate it's not the intention of Gavin Brown's amendment, but it would seem contrary to the spirit of the bill to support any amendments that could potentially lead to tax avoidance measures being watered down. Having said that, I think we are very sympathetic to the arguments put forward by the Scottish Property Federation, who have suggested that an unintended consequence of the withdrawal of subsale relief is that it will inhibit forward funding arrangements, which are important in the context of financing major commercial development in Scotland. It's important, therefore, in seeking to protect LBDT against tax avoidance, we don't inadvertently introduce a competitive disadvantage that may drive companies' commercial developments to other parts of the UK. The SPF have suggested that the Government commit to identifying relief through using Section 27 of the bill, and I'd welcome the Cabinet Secretary's comments on that issue.
Thank you. Cabinet Secretary.
Presiding Officer, there is actually an awful lot of what Gavin Brown and Ken McIntosh have said with which I agree. I think this is a difficult issue with which the Finance Committee has wrestled. I think Mr Brown fairly makes the point that nobody wants to make Scotland less competitive for these transactions. Mr McIntosh has made the fair point that in doing so we don't want to open Scotland up for tax avoidance, and I broadly sympathise with both of those positions. The amendments that Mr Brown has brought forward, I think I can't support, and I will, but I have more to say about the whole subject. The fundamental weakness at the heart of Mr Brown's amendment is around the absence of a definition of transfer of rights. Transfer of rights could apply to any property transaction whatsoever, so we could potentially be opening up, by the acceptance of these amendments, a very wide possibility for additional release, which I don't think, having listened to Mr Brown, is his intention, but I think it would be a consequence of the amendment that he has brought forward. As I've stated to the Finance Committee and to the Chamber at stage one of the bill, I have no intention of replicating in devolved taxes provisions that have particularly given rise to avoidance activity. That is why I chose not to replicate the subsale rules in the UK legislation when the LBTT bill was introduced to this Parliament. The Finance Committee and key stakeholders have supported that stance. However, concerns have been raised, and the Finance Committee is familiar with these, that the absence of a form of subsale relief could have a negative impact on transactions that depend on forward funding arrangements. What I don't want to do is to put forward measures in the bill at this stage which, without proper and due consideration, might simply create the opportunities for avoidance activity. So I have no wish for history to repeat itself in relation to the formulation of these measures. When the Finance Bill 2003 was introduced at Westminster, there was no equivalent of what is now Section 45 of the Finance Act, which sets out the so-called transfer of rights rules. This section was inserted following lobbying by the development sector during the bill's passage. I believe that this was done with the best of intentions, but I draw the parallel to highlight that the result of making a hasty amendment to legislation can lead to provision that has a far wider result than Parliament intended. Scottish ministers have no intention of making the same mistakes. However, I recognise two things. The first is that the revamped transfer of rights rules are currently making their way through Westminster in the Finance Bill 2013, and we will monitor their progress with interest. The second is the valuable meetings that stakeholders have had with myself and with officials. These meetings have highlighted the importance of being able to apply a form of subsale relief in development transactions. These discussions have also highlighted the complexity of these transactions and the consequent need to ensure that we do not inadvertently create opportunities for avoiding LBTT, as has been the case with stamp duty land tax. I am therefore prepared to give further consideration to whether measures can be drafted that provide for the issues raised with me by the industry without jeopardising the integrity of the bill. I am prepared to consider a measure where relief should be available only when development is contemplated and takes place within a given period. I will not agree to relief being available to parties who acquire land speculatively and who do not then bring the land into use. I would require that any relief ought to be subject to pre-clearance. This would involve the taxpayer alerting the tax authority in advance to a claim for relief on their part of a transaction, and the tax authority, in this case Revenue Scotland, indicating whether such a claim would be accepted or rejected on the basis of the information provided. I also envisage that a form of clawback of any relief that was granted by the tax authority be applied. The principle of granting relief, and then, if circumstances change, withdrawing it, is already established in the bill in the case of group relief. This clawback would involve the tax authority being able to call for payment of LBTT that had been relieved if the conditions of the relief were not met. This would most likely be used if development did not take place within a certain time frame. There are other considerations too. For instance, we need to settle the basis for the LBTT charge, where there are several options. We need to adopt an approach that is fair to the taxpayer but also collects the right amount of tax. And we will want to ensure the correct LBTT charge is levied where part of a plot is sold on to another developer at an enhanced value. These issues require further work, including with stakeholders. Commercial arrangements are, Presiding Officer, complex, with a lot of contracts being confidential in nature, and therefore many of these questions are not easy to answer. A further key consideration is what anti-avoidance provision the legislation should make. In order to assist me in answering these questions and resolving these issues, I am going to convene a working group, and today have written to a number of interested parties to invite them to join that group to explore these issues. One outcome from the work of this group may be that I decide to use the power afforded in section 27(3) of the bill, to which Mr McIntosh referred, to provide a new relief which should apply to subsale transactions. I have made clear, however, the conditions that I believe should apply to any such relief, and any such order, of course, would be subject to scrutiny by Parliament. I want to be very clear with Parliament and with the industry today. If the outcome of the work from this group does not convince me that a relief can be given without significant risk of avoidance activity, then there will be no order brought to Parliament by the Government. I reiterate, I have no intention of devolved taxes being vehicles for avoidance. In all of these circumstances, and given the Finance Committee's strong support for not giving scope to avoidance behaviour, I would invite Mr Brown to recognise the commitment the Government has demonstrated in considering this issue and to withdraw the amendment in advance of the further detailed work being undertaken as quickly as we possibly can do.
Thank you. I now call on Gavin Brown to wind up and press to withdraw his amendment.
Thank you, Deputy Presiding Officer. Can I start by saying that I do think that Mr Swinney has engaged on this issue over the course of the bill, and I welcome many of his remarks at the end there, particularly the convening of a working group of stakeholders who are experts in this area. I still think we're probably just slightly apart in terms of what I want and what he wants. His rests on section 27 still, which is a may. Mine rests more on a must, that they must bring something forward, having taken into account. I don't think the amendment as drafted is quite as wide as he suggested. It does allow the Government to decide who the appropriate stakeholders are with whom to consult, and that group, I think, is almost obvious from the work that's been done already. It also allows the Government to decide which rights they think ultimately appear to be appropriate, but it's simply that they must bring forward some. Sure.
I'm grateful to Mr Brown for giving me, and I hear the point of distinction that he makes between his position of must and my position of may. I would say to him that I think the position that I've adopted is the safer position for Parliament to protect the integrity of the bill, which is the consideration that I have, that I do not want Parliament to oblige the Government to bring forward legislation, because we may find it is impossible to provide a sufficiently robust proposition to avoid any tax avoidance. And I think the whole of Parliament does not wish to repeat the mistakes that were made in the stamp duty land tax legislation.
Kevin Brown.
I welcome his intervention, Deputy Presiding Officer, but I do think things have moved on substantially since the stamp duty land tax legislation was brought into force. Indeed, changes, as he mentioned in his own contribution, have been afoot for some time at a UK level to minimise, I think, substantially tax avoidance. I think we are still some distance apart. There is a balancing act between being competitive and minimising aggressive avoidance of tax. I find it difficult to foresee circumstances where he convenes a working group and there is simply absolutely no relief whatsoever that can be brought forward. From examining what has happened south of the border, from listening to the evidence given to the Finance Committee, I'm sure it will be far tighter up here, but I just can't foresee any circumstances where there is nothing at all that can be brought forward. I just think the Scottish Government has tipped the balance slightly towards away from being competitive. I don't think we're miles apart, but on that basis I will press Amendment 70.
Thank you very much. So the question is that Amendment 70 be agreed to. Are we all agreed? We are not agreed. There will therefore be a 1-minute division. Please vote now. The result of the vote on amendment number 70 in the name of Gavin Brown is yes, 14, no, 102. There were no abstentions and the amendment is therefore not agreed. I now call amendments 14 to 23, all in the name of the Cabinet Secretary and all previously debated. And I invite the Cabinet Secretary to move amendments 14 to 23 en bloc.
Moved en bloc, Presiding Officer.
And does any member object to a single question being put on amendments 14 to 23? And as no member objects, the question is that amendments 14 to 23 are agreed to. Are we all agreed? Yes. Excellent, we are. We now move to Group 8, which is partnerships, and I call amendment 71 in the name of Gavin Brown and a group on its own. Mr Brown, to move and speak to amendment 71, please.
Thank you, Deputy Presiding Officer. The partnership provisions as drafted received a fair bit of criticism from stakeholders throughout the course of the bill. The bill was really trying to create a tax based on Scots law, principles and practice, and in many areas, I have to say, it has achieved that remarkably well. However, the partnership provisions, which are a considerable part of this bill, broadly mirror the much criticised stamp duty land tax provisions, give or take a few amendments. At stage 2, I tried to have Schedule 17 deleted in its entirety, and that was defeated. The Cabinet Secretary's primary argument at stage 2 was that he was concerned about a vacuum. So Amendment 71 has tried to take on board the main concerns raised by the Government. It means that they must review Schedule 17 before the tax is first charged. It means they must consult, but it doesn't force them to use the regulatory power. It simply says that where they don't use that power under Section 49, they have to explain why not. So it's an attempt to take on board criticisms and complaints and take it forward in a different direction. I therefore move Amendment 71.
Thanks. Ken McIntosh.
I simply want to add my support for the amendment in Gavin Brown's name. Clearly there was a lot of evidence, a lot of concern in the evidence to the committee about the effectiveness of this particular piece of legislation, which has been pretty well copied in its entirety from the stamp duty legislation. The amendment, as I understand it from Mr Brown, simply asks for a review, and there are 2 years before this legislation is actually implemented, which is plenty of time, I would have thought, for the Minister to carry out a review. So on balance, given the time frame, it seems reasonable to accept Mr Brown's amendment.
Thank you very much. Cabinet Secretary.
Presiding Officer, I'll speak to Gavin Brown's amendment number 71. As I've previously acknowledged to the Finance Committee, the partnership provisions in the bill are complex, but as part of the SDLT legislation, they deliver 2 policy objectives that I believe are fair and which I wish to retain. The first is that partnerships get a partial relief from LBTT when they acquire a chargeable interest in property from a partner to reflect the partner's retained interest in the property. The same principle applies when a chargeable interest is taken out of a partnership. At this stage, I have no intention of interfering with this well-established relief. The second objective is to minimise the risk that transactions involving partnerships become a means of avoiding LBTT. Schedule 17 contains a number of provisions to tackle avoidance. On the 5th of June, I gave an assurance to the Finance Committee in response to amendments lodged at Stage 2 on this provision by Mr Brown. I undertook that officials would discuss with stakeholders the issues that they felt should be addressed in relation to these provisions. In making that commitment, I was conscious that it may be possible to address many of these issues by having clear guidance to accompany legislation. If legislative change proves to be necessary to address the issues, we have already included at Stage 2 a regulation making power to enable us to amend Schedule 17. As I stated to the Finance Committee on the 5th of June, I do not want to anticipate the outcome of these discussions on the partnership provisions. I will keep the committee abreast of progress with these discussions, and if recommendations to amend Schedule 17 emerge, I will return to Parliament in due course with legislative proposals for approval. In relation to Mr Brown's amendment, I infer that he wishes to use the legislation to oblige me to and officials to work with stakeholders to look at the partnership provisions without defining the objectives. In light of my earlier commitment repeated today that officials will work with stakeholders to understand their concerns about the provisions and seek to meet these concerns, either through better guidance or through legislative change, or indeed both, and that I will update the Finance Committee as to progress, I would invite Mr Brown to withdraw his amendment.
Thank you. Gavin Brown to wind up and press to withdraw his amendment.
Thank you, Deputy Presiding Officer. These provisions are complex. Many professionals will say they simply do not understand properly how they operate, and you have to have root and branch reform, many of them, of course, rooted in English law as opposed to Scots law. I thought he would go slightly further today. The idea of having consultation with stakeholders or speaking to some stakeholders is well and good, but they're not obligated to do anything. And I have a genuine fear that because it's complex, because it's potentially seen as unexciting, this drifts slightly, and in April 2015 we end up with exactly the same Schedule 17, or broadly the same Schedule 17 that we currently have. Having listened carefully to the evidence given from stakeholders and those who really engage with this on a daily and weekly basis, I think it's too important just to leave to chance. I think there has to be something within the bill that forces the government to follow this through, and therefore on that basis I will press amendment number 71.
Thank you very much. So the question is that amendment 71 be agreed to. Are we all agreed? We are not agreed. There will therefore be a 1-minute division. Please vote now. The result of the vote on amendment number 71 in the name of Gavin Brown is yes 51, no 65, and the amendment is therefore not agreed. We now move to Group 9, which is regarding trusts. And I call Amendment 24 in the name of the Cabinet Secretary, grouped with Amendment 28. Cabinet Secretary to move Amendment 24 and speak to both amendments in the group, please.
Presiding Officer, Amendment 24 adds a power to amend Schedule 18 on trusts by regulations. Amendment 28 ensures that any regulations made will be subject to the affirmative procedure. Given that we amended the bill at Stage 2 to modify Schedule 17 and partnerships and trusts are intrinsically linked, we consider it necessary to have a flexibility to amend Schedule 18 too. I move Amendment 24.
Thank you. And as no member has asked to speak, would you like to wind up?
No further remarks.
Thank you. So the question is that Amendment 24 be agreed to. Are we all agreed? Yes. We are, I think. I now call Amendment 25 in the name of the Cabinet Secretary, already debated with Amendment 6. Cabinet Secretary to move formally.
Moved, Convener.
And so the question is that Amendment 25 be agreed to. Are we all agreed? We are. Thank you very much. So we now move to Group 10, which is regarding licences. And I call Amendment 26 in the name of Gavin Brown, grouped with Amendment 30 and 33. Gavin Brown to move Amendment 26 and speak to all amendments in the group, please. Mr Brown.
Thank you, Deputy Presiding Officer. Can I start this group by acknowledging the work carried out by the Scottish Government, the Bill team and John Swinney, in an area where they have listened, I think, to a lot of what has been said, and we end up with a very different position at Stage 3 as we had when the bill was first produced. In terms of these amendments, Amendment number 26 forces a consultation before bringing any new types of licence into the scope of the tax. A particular concern has been raised by stakeholders about hotel operators' licences, and I wonder if the Cabinet Secretary would have in his contribution anything to say about that. Amendment number 30 means that any changes have to be affirmative. Amendment 33 just removes it from, I suppose, a slightly lighter procedure. As I say, they have listened. Just the one issue where I do have a slight contention is in their Stage 1 debate, in response to me, the Cabinet Secretary said, I confirm that there will be an indication of the licences that are included in the scope. The bill will specify which licences will be covered, rather than seek to establish a comprehensive list of all the circumstances that are not covered. I hope that helps members. So we know that at the moment none are covered, but I don't think we have a clear enough indication from the Government of what he's thinking about covering, and I therefore move Amendment 26.
Thank you very much. Ken McIntosh.
Officer, at present, so I just rise to indicate our support for the amendments from Gavin Brown. At present, property under licence is exempt from LBGT. My understanding of this amendment is that it relates to prescribing certain types of property made under licence that would be treated as land transactions and therefore be liable for the tax. My understanding is that the Cabinet Secretary suggested earlier that he would consult on these matters with stakeholders before introducing regulations. My understanding is that the amendment simply calls for a consultation and then suggests that subordinate legislation on licences would be subject to affirmative procedure, and that strikes me as something that the Parliament would support.
Okay, Cabinet Secretary.
Presiding Officer, I'll speak to Amendment 26 before turning my attention to Amendments 30 and 33. As Mr Brown has explained, Amendment 26 would place a duty on Scottish Ministers to consult interested parties before prescribing which licences to occupy non-residential property are to be subject to land and buildings transaction tax. I have already given a commitment at Stage 2 of the bill to consult on such proposals. In response to a question from Mr Brown at the Finance Committee on the 29th of May, I explained that during the passage of the bill we would not define the type of licence that will be considered for LBTT, but instead we would do so separately through secondary legislation. I then went on to say, and I quote here from the official report of the 29th of May, the proposed approach is clearer and will be more administratively efficient. Of course, there will be consultation around and consideration of the secondary legislation that emerges on the issue. I'm happy to repeat this assurance again today, and in the light of that would ask Mr Brown to withdraw Amendment 26. Mr Brown asked me specifically about hotel operator licences, and I think from what I said on the record at Stage 2, although I will have to just confirm this, I made it clear that hotel operator licences would not be part of the scope of consideration, but I'll check if that is in fact a correct reference. Presiding Officer, the purpose of Amendments 30 and 33 is to ensure that all regulations made under Section 51A(1) of the Bill are subject to the affirmative procedure. These amendments, I believe, are entirely in order, and I will encourage members to support Amendments 30 and 33, but I would invite Mr Brown to withdraw Amendment 26.
Thank you very much. Mr Brown, to wind up and press to withdraw your amendment.
Thank you, Deputy Presiding Officer. I think basically because the government said at stage one that they would be saying what was included, I'm of a mind to press purely so that it forces them to consult, and on that basis I'll press 26.
Very much. And the question is therefore that Amendment 26 be agreed to. Are we all agreed? We are not agreed. There will therefore be a 1 minute division. Please vote now. The result of the vote on amendment number 26 in the name of Gavin Brown is yes 49, no 67. There were no abstentions, and the amendment is therefore not agreed. I now call amendment 27 in the name of the Cabinet Secretary, already debated with amendment 1. Cabinet Secretary to move formally, please. Thank you. So the question is that amendment 27 be agreed to. Are we all agreed? We are. I call amendment 72 in the name of Gavin Brown, already debated with amendment 70. Mr Brown to move or not move? Not moved. Yes, so I now call amendment 28 in the name of Cabinet Secretary, already debated with amendment 24. Cabinet Secretary to move formally?
Moved.
The question is that amendment 28 be agreed to. Are we all agreed? We are. Thank you. Call amendment 29 in the name of the Cabinet Secretary, already debated with amendment 6. Cabinet Secretary to move formally, please.
Moved.
Thank you. So the question is that amendment 29 be agreed to. Are we all agreed? Thank you. Call amendment 30 in the name of Gavin Brown, already debated with amendment 26. Mr Brown to move or not move?
Moved.
Thank you. So the amendment having been moved, the question is that amendment 30 be agreed to. Are we all agreed?
Yes.
Thank you. We are. I now call amendment 31 in the name of the Cabinet Secretary, already debated with amendment 2. Cabinet Secretary to move formally. Thank you. So the question is that amendment 31 be agreed to. Are we all agreed? Thank you. We are all agreed. I now call amendment 73 in the name of Patrick Harvey, already debated with amendment 69. Mr Harvey to move or not move?
Not moved.
Thank you. So we'll now call amendment 32 in the name of the Cabinet Secretary, already debated with amendment 6. Cabinet Secretary to move formally?
Moved.
Thank you. So the question is that amendment 32 be agreed to. Are we all agreed? We are. Thank you. Call amendment 33 in the name of Gavin Brown, already debated with amendment 26. Mr Brown to move or not move?
Moved.
Thank you. So the question is that amendment 33 be agreed to. Are we all agreed? Thank you. We are agreed. And we now move to section 69, which is Group 11, Crown application. I call amendment 34 in the name of the Cabinet Secretary in a group on its own. Cabinet Secretary to move and speak to the amendment, please.
Presiding Officer, this minor amendment ensures that section 68, which relates to the application of the bill to the Crown, comes into force on the day that the bill receives royal assent. The amendment adds a reference to section 68 to section 69(1) of the bill, and I move amendment 34.
Thank you. And as no member has indicated a desire to speak, Cabinet Secretary, would you want to wind up?
Further remarks.
Thank you. So the question is that amendment 34 be agreed to. Are we all agreed? We are. We now move to Schedule 1 and I call amendments 35, 36, 37, 38, 39, 40, 41, 42 and 43, all in the name of the Cabinet Secretary and all previously debated. And I'd invite the Cabinet Secretary to move amendments 35 to 43 en bloc, please.
Moved en bloc, Presiding Officer.
And does any member object to these amendments being moved en bloc? And as no member objects to these amendments being moved en bloc, the question is that amendment 35 to 43 are we all agreed to? We are. Thank you. I now call amendment 74 in the name of Patrick Harvey, already debated with amendment 69. Mr Harvey, to move or not move?
Not moved.
Thank you. So we'll now move to amendments 45, 46, 47, 48, 49, 50, 51, 52, goodness, all the way to 68 in the name of the Cabinet Secretary and all previously debated. I'd invite the Cabinet Secretary to move amendments 45 to 68 en bloc. Thank you. Does any member object to these being moved en bloc? And as no member has, the question is that amendment 45 to 68 are agreed to. Are we all agreed? We are. Thank you very much.
Point of order, President.
Cabinet Secretary.
Amendment 44. I'm not sure if you called Amendment 44. Has that been called?
Yeah, it's part of the block. It's part of the block, yes.
It's not.
It is part of it. I just couldn't read it out. The script's wrong, but it's part of the block.
Thank you for your point of order. Our script is not all that it might be, but we did, if we're all agreed, call Amendment 44. It is part of that block, and we should have, but so thank you for drawing that to our attention. So if we're all agreed, we'll take 44 as well and agree to it. Thank you very much. And that ends the consideration of amendments. My thanks for your forbearance.
The next item of business is a debate on motion number 7107 in the name of John Swinney on the Land and Buildings Transaction Tax Scotland Bill. Can I invite members who wish to speak in this debate to press the request to speak buttons now? And I call on John Swinney to speak to and move the motion. Cabinet Secretary, 10 minutes or less if possible. Thank you.
Presiding Officer, today's Stage 3 debate on Land and Buildings Transaction Tax is something of a landmark for this Parliament. This is the first tax bill in Scotland for 300 years, 308 years to be exact. The Chamber may be interested to know that the last tax bill passed by a Scottish Parliament was in 1705 when, and I quote from the Act itself, Their Majesties King William and Queen Mary did thereby grant and dispone to said town of Glasgow and community thereof the imposition of 12 pennies upon the price of ale and beer to be vended and sold within the town and liberties thereof. So interesting that the last tax act was about setting alcohol taxation in Scotland. So not much changes after 308 years. To bring the debate further up to date, Presiding Officer, in the New Statesman of the 25th of June, there is an article which starts with the words, "Good news if you're Scottish. Your government is fixing one of the most ridiculously broken parts of the British tax system." And in this article by a gentleman called Alex Hearn, he makes the point that the reforms taken forward by the Scottish Parliament today represent a significant transformation in the way in which taxation of property is being handled in Scotland as a consequence of this Parliament acquiring those responsibilities and having the opportunity to legislate for change. Presiding Officer, the Land and Buildings Transaction Tax is coming to a conclusion this afternoon. The second tax bill in 308 years, the landfill tax is falling hard on its heels, and preparations are continuing for the introduction of the tax management bill in the autumn. I can also report to Parliament that both Revenue Scotland and Registers of Scotland are making good progress working together on the implementation of the legislation. These two taxes, devolved under the provisions of the Scotland Act, are a modest start, but only a first step in strengthening the tax powers of this Parliament and enabling the Parliament to take the decisions on taxes and revenues that match Scotland's interests and create opportunities for Scotland to flourish economically and socially. As I first articulated in this chamber just over a year ago, the Government's proposals for taxation are firmly founded on Scottish principles that have stood the test of time. Adam Smith in 1776, in his inquiry into the nature and causes of the wealth of nations, set out 4 maxims with regard to taxes: the burden proportionate to the ability to pay, certainty, convenience and efficiency of collection. These maxims may be too late for the beer tax of 1705, but they point towards a system that will meet the needs of a modern 21st century Scotland grounded on solid foundations. To those 4 principles, this Government will seek to ensure that the devolved taxes will contribute to our core purpose of delivering sustainable economic growth for Scotland and meeting the distinctive needs of Scotland. Land and Buildings Transaction Tax represents a significant improvement on the tax that it replaces, the UK's stamp duty land tax. We will do away with the nonsense of the slab structure of SDLT, in which 3 times as much tax is paid when a house value nudges above the $250,000 threshold. This has caused market distortions and leads to the false recording of house prices in an effort to avoid paying tax at the higher rate. Land and Buildings Transaction Tax will solve this in Scotland at a stroke by substituting a progressive structure where only the amount above the threshold will incur tax at the higher rate. This is a change that the Council of Mortgage Lenders and others have been calling for since stamp duty land tax was introduced in 2003. It is also clear from the earlier stages of the bill that there is cross-party support for this approach within the Chamber. The Government and indeed this Parliament has shown the vision to get on and to do the right thing. Presiding Officer, there are a number of other areas where the bill improves the equivalent legislation for stamp duty land tax. To encourage prompt payment of tax, a tax return and payment arrangements satisfactory to the tax authority will have to be made before an application to register a land transaction can be accepted by Registers of Scotland. Revenue Scotland and Registers of Scotland have started planning for an IT solution which will allow for the submission of a tax return and payment to be made, with a paper alternative for those who cannot use the online system. We have rationalised the number of tax reliefs available to simplify the tax and the statute book. Under SDLT, there are a number of tax reliefs that only apply in England and Wales, and there are others which aren't being claimed. These have not been replicated in the Land and Buildings Transaction Tax Bill. And we have, wherever possible, adopted Scottish legal terminology to make the legislation more comprehensible to the Scottish reader. Presiding Officer, for a number of years, the subsale rules for stamp duty land tax have been the subject of aggressive tax avoidance activity. A number of different ways have been found in which to take advantage of these rules in an effort to avoid paying any stamp duty land tax whatsoever. Such activity is not welcome in Scotland, and I'm keen to encourage a culture of responsible tax paying, and those who doubt that can expect to see timely and effective action from Revenue Scotland to protect the tax base. In my closing remarks in the Stage 1 debate, I committed to exploring options to ensure that the property development industry in Scotland was treated fairly in the absence of the subsale rules. Since then, I have met with representatives from the industry who have provided a range of insights and suggestions, and I hope that the conclusion that we arrived in the consideration of amendments earlier on gives both the industry satisfaction that the Government is engaging seriously on these questions, but crucially also gives Parliament reassurance that the Government is resolute in its determination not to see the integrity of this legislation undermined by avoidance activities. We have considered also, Presiding Officer, the issue of partnerships and trusts, and again come to conclusion as to how we can advance these questions. Presiding Officer, during the course of this bill, a great deal of work has been done to develop legislative provisions in relation to the taxation of non-residential leases. And I want to single out this area as one particular area of good practice in the formulation of the bill. In the course of taking forward these very complex issues, we've had the benefit of being able to discuss these issues with members of the Non-Residential Leases Working Group, which has included representatives from the Scottish Stamp Practitioners Group, the Institute of Chartered Accountants in Scotland, the Law Society of Scotland, the Chartered Institute of Taxation and the Scottish Property Federation. I'd like to express my thanks to the members of that group for the way in which the group has enabled the consideration and agreement of a comprehensive approach covering a whole range of issues, and their time and expertise has greatly strengthened the parliamentary scrutiny of these matters. This is a good example of how the legislative process in Scotland can be made accessible to stakeholders. Working closely with stakeholders has been a feature of this bill, and it's something that I want to continue as we take forward the examination of tax issues, and it's been a hallmark of the establishment of the Tax Consultation Forum, which is already giving the Government very substantial advice in the formulation of the tax management bill that will shortly come to Parliament. Presiding Officer, can I conclude by thanking the Finance Committee for the detailed scrutiny they undertook of the bill at its earlier stage. The bill covers a number of different policy areas, and the committee heard evidence from a very broad range of stakeholders. We can take pride in the fact that today we are giving evidence of Parliament's ability to shape legislation that addresses a diversity of significant issues. The bill is an example of what the Parliament can achieve if we work collaboratively together, and I hope that the bill will this evening attract support across the political spectrum in Parliament today. In conclusion, Presiding Officer, I move that the Parliament agrees that the Land and Buildings Transaction Tax Scotland Bill be agreed tonight.
Many thanks. We're extremely tight for time. I now call Ken McIntosh, maximum 7 minutes.
Thank you, Presiding Officer. And there's been very little fuss about today's bill. It has broad political agreement across the Chamber. It has broad support amongst homeowners and businesses. And yet I think it is worth noting, even if this is not the most earth-changing legislation, that just for the record, it is Scotland's first new tax in more than 300 years. It is yet another example of devolution working well. The Scottish Parliament taking control of this property transaction tax and designing a system to suit Scotland's needs whilst retaining all the advantages of working within the political, social and economic union that is the UK. Now, although today we have agreed on the principles of the new Land and Buildings Transaction Tax, there's still a great deal of detail to be worked out. There is, for example, the practical issue of how the collection agency, Registers of Scotland, will interact with the new supervisory body, Revenue Scotland. There is the rather important matter of negotiation and agreement as to how much the block grant will be reduced when the new tax is introduced. And of course there is the question which I suspect most home buyers and businesses will most want to hear answered, and that is letting them know how much they will pay. What will be the rates at which LBTT will be introduced? On the first of these points, alongside the devolution of LBTT itself, perhaps the most practical and immediate positive benefit will be the move from an inefficient and unfair tiered or slab structure of stamp duty to the progressive rising scale of LBTT. Stamp duty has long been broadly redistributive. In other words, a high rate of tax is generally applied to more expensive properties, with in fact no stamp duty on properties below £125,000. However, applying the higher percentage rates to all of the properties above a certain threshold has created highly marginal rates of tax at those new banding levels and has led to distortions in the housing market and in the application of the tax itself. This new system will smooth out those inequities and will ensure a more efficient market. It will be fairer to buyers and sellers alike. Now, when this bill is implemented, the block grant will of course be adjusted to remove a sum equivalent to the money we currently receive from stamp duty levied across the UK. It is worth noting at the very least that the UK and Scottish governments have already offered us quite widely varying estimates as to how much the grant should be reduced by. On the one hand, that's not surprising given the collapse of the property market and therefore in the number of sales on which stamp duty has been levied over the past few years. But it is important that an agreement is reached and that any such agreement is fair, not just for Scotland, but for the rest of the UK too. The Cabinet Secretary has placed great stock in the past on providing stability in the public finances, and for that reason alone, I would urge the Cabinet Secretary to work towards reaching agreement in this matter sooner rather than later. I'm certainly not asking members to rethink their support for this bill, but I suspect there may be a marginal downside to devolving LBTT, I haven't made the exact calculation, but given that stamp duty is a broadly redistributive tax, I believe there are proportionately far more expensive properties in London and the south east of the UK than there are in Scotland. If that is indeed the case, Scotland will currently be amongst those parts of the UK who marginally gain from the redistributive effect of that tax. I mention that point as it is also worth noting that when LBTT is introduced in Scotland, many of the properties at the higher end of the scale will be in Aberdeen, Aberdeenshire, Edinburgh and Glasgow. At the very least, the new system will create a tension between our support for localism, local control, and our belief in a nationally applied progressive and redistributive system of taxation. One of the most important issues still to be resolved is the timescale for the publication of the new tax rates. I will not repeat all the arguments we've just heard debated in the amendment stage and indeed at committee stage, but I hope the Cabinet Secretary will bear in mind that business in particular is clamouring for greater certainty in this area. The Cabinet Secretary has stated that his broad approach is to try to maintain revenue neutrality. But even within this policy intention, there is quite a degree of scope for winners and losers. I believe when the bill was first outlined, the Cabinet Secretary suggested that 95% of people would be better off under LBTT. If that is the case, then clearly the 5% that are worse off may be disproportionately affected. There's a particular worry in the commercial property sector that high-value commercial property may bear some of this disproportionate impact. Businesses are used to testing our words as politicians against our actions as parliamentarians or as government ministers. And I would urge this government, and this minister in particular, to publish his proposals as soon as possible to introduce some certainty. The fact that the Cabinet Secretary has repeated his intention not to publish the information before September 2014, in other words, it won't be published before the referendum, has not helped assuage that anxiety. It suggests, first of all, that it is less of a priority, and furthermore begs the question, if there is nothing to worry about and everyone will be broadly unaffected or even slightly better off, why the delay in making the announcement? Mr Mason.
John Mason.
I thank the member for giving way. Would you also accept that Chancellors of the Exchequer at Westminster do tend to make tax announcements quite late in the day?
Ken McIntosh, you're approaching your last minute.
I do. I'm not quite sure that's a killer point. I don't think that really answers the point about the certainty that we're looking for. We don't have certainty at the moment, and the Cabinet Minister has it within his power to offer that to businesses and to homeowners. Now, turning to the administration of the new tax, the bill states that Registrars of Scotland will have a role in the collection of revenues alongside Revenue Scotland. Clearly, having two organisations involved in one tax does create room for complexity and confusion. I would urge the Minister to clarify their roles as soon as possible. Now, as the Minister knows, we have given our strong support to the introduction of a robust general anti-avoidance measure. However, one of the exceptions we did make was on energy efficiency, and I would urge the Minister to return to that. But to conclude, Presiding Officer, there are a number of issues still to be resolved, much in the way of detail still to be published, but the Parliament is of one mind that today marks a major step forward in improving the tax system in Scotland. The bill reflects a number of principles around which we can agree and reflects an approach both progressive and redistributive, which we believe can help shape the modern, prosperous and socially just Scotland of which we can all be proud.
Many thanks. And now calling Gavin Brown with 5 minutes or less.
Thank you, Deputy Presiding Officer. Certainly from our side of the chamber, we welcome the devolution of this tax and welcome the bill, which of course we will support at 5 o'clock, at 5:40 at decision time when it comes. I was reminded when the Cabinet Secretary talked about this being the first new tax for well over 300 years. One practitioner in tax, who shall remain nameless, said that new taxes are a bit like buses, and indeed by the end of 2013 we will have another one with which to contend in the shape of the Scottish landfill tax. There are many elements of this bill that we welcome. I think one of the strongest decisions taken by the Scottish Government was the decision to remove the existing slab structure found in SDLT. That has led to market distortions without any shadow of a doubt, and that one simple move, I think, will make a big difference to the marketplace, and I've yet to find anybody from any profession who has a bad word to say about that particular decision. Over the course of the bill, as I think as indicated in the Stage 3 voting on amendments, there are also, I think, a number of areas where the Scottish Government has made strong progress and ought to be I think, credited for the work that they've done. The Cabinet Secretary talked about the working group that he set up in relation to non-residential leases. I too joined him in commending that group, which sat down, rolled their sleeves up and pulled together some provisions which are complex, but which I think are far superior to those that they replace. And indeed, as I said earlier, the decision that he took in relation to licences, where initially they were a part of the tax, now they are not, apart from those which may be put in at some later date. We have, of course, had discussions about areas where we disagree too. As the Cabinet Secretary will know, I find myself in particularly in a different position in two areas. One, in relation to the timings of the rates. I won't rehearse all of it other than to respond to the intervention that John Mason made. John Mason is right to say that the Chancellor of the Exchequer has raised stamp duty on budget day. I think March 2012 was a particular example of that. The concern, though, that businesses raise with me at the moment is that this is an entirely new tax. It is a new framework. There will be new thresholds. We don't know exactly how many. There will be new rates at every level, apart from, obviously, the zero rate or the nil rate. So I think there is greater uncertainty with an entirely new tax when compared to an existing tax, even where there are changes late in the day. We disagree, obviously, as well on subsale relief. Again, I won't rehearse all of it. Suffice to say that I do feel the Scottish Government has slightly overstated the case in relation to tax avoidance and not quite taken into account enough areas of competition. But he's outlined what he intends to do with that. We're just in a slightly different place. But I note that most of the group that he mentioned in relation to residential and to non-residential leases, ICASA, Law Society, Chartered Institute of Taxation, Scottish Property Federation and others, I think take a view broadly closer to what I have suggested compared to the Scottish Government approach of trying to exclude it all and only look at bringing in one or two parts. There is still work to be done. I think the bill acknowledges that in terms of specific regulatory powers that are given. And with just a few moments left, I would say Mr Swinney quoted the New Statesman article which said we're fixing one of the most ridiculously broken parts of the British tax system. There are still within the bill some parts that people would deem to be broken, in particular the partnerships provisions, but there are also bits in there in relation to the trusts provisions that need to be looked at too, and I'm glad that the regulatory power was specifically brought in at stage 3 there. Deputy Presiding Officer, as I said in opening, we will support clearly this bill at decision time today, but there are a couple of areas where we still disagree, and I press the Government, even at this late stage, to look at where they can make progress on those specific areas. Thank you.
Many thanks. We now turn to the open debate. I can only give members 3 minutes, and even at that I may have to drop speakers. Kenneth Gibson, to be followed by Malcolm Chisholm.
Thank you, Presiding Officer. As convener of the Finance Committee, the lead committee in this bill, I'm pleased to be taking part in today's debate on a subject which featured heavily in our work this year. The complexity of establishing a fair and workable system of taxation is apparent, with the need to iron out inequity, learning from the mistakes of old legislation, repeatedly altered, whilst trying to simplify the system within the powers of this Parliament has not been easy, and I would like to thank the committee clerks, committee colleagues and all those who contributed to the evidence-gathering sessions. Their input has been invaluable as the bill progressed, helping to offer a fuller picture of how this new tax could, should and will operate. The Land and Buildings Transaction Tax Scotland Bill will be the first of 3 related tax-raising bills to come before the Finance Committee and this Parliament following the passage of the Scotland Act 2012. And it's clearly in the interest of everyone to ensure new taxes are progressive, relatively simple and effective. LBTT will replace stamp duty land tax, described by the Institute of Fiscal Studies as wholly ill-conceived. Perhaps most notable of its faults is the fact that stamp duty land tax is charged on the basis of a slab system, which creates significant distortions. For example, as pointed out in the Ernst & Young report, Grasping the Thistle, not to be confused with Mike Russell's book of the same title, a non-residential property acquired for £249,000 attracts stamp duty at 1% or £2,490, whereas one bought for £251,000 incurs a charge of 3% or £7,530. LBTT will offer a more progressive tax, avoiding sudden increases in liabilities that are a feature of the slab. Furthermore, as a recent Sunday Times article on 28th of April pointed out, stamp duty is open to a series of tax avoidance schemes which HMRC is now trying desperately to close. Whilst the finer details of stamp duty mitigation schemes are kept secret by some legal firms, it is known that subsidy relief through a complex system involving the setting up of third-party companies can be exploited on behalf of the buyer. I am pleased that the bill addresses this issue. Whilst I am aware that many property developers use subsidy relief for wholly commercial purposes, the bill will properly legislate to cover these specific commercial transactions. Tax avoidance is clearly an important issue and has received much attention in recent months. I am therefore pleased the bill is taking steps to close tax loopholes. As the Scottish Government doesn't intend to increase the overall revenue take, this means everyone should pay less. Of course, the Scottish Government intends to tighten things up even further by introducing a general anti-avoidance rule through the Tax Management Bill later this Parliament. This is a move which will enjoy public support. However, according to Ernst & Young's survey I cited, it also has the support of 78% of businesses operating in Scotland across an array of sectors. As an aside, I believe this shows the Government can act in the public interest by collecting taxes duly owed by businesses without scaring them away or damaging the economy, a scenario some are all too keen to depict, and I suggest the UK Government will wish to reflect on that. In conclusion, LBTT is a first step towards a Scottish approach to a fairer taxation system, and it is important this is achieved with as much consensus as possible. I am encouraged this has indeed been the case, both in committee and in the Chamber, with a majority of amendments agreed without division. I am confident that following the passage of this bill, and when the improvements and benefits of it are realised, it will become apparent that all, and not some, taxpayers should be devolved to this Parliament.
Many thanks. Malcolm Chisholm to be followed by John Mason.
Presiding Officer, I very much welcome this bill, which will soon become the first tax act in Scotland since the Tax on Alcohol in Glasgow Act of 1705, and I thank the Cabinet Secretary for that interesting information. As he said, he hopes it will be the first step in strengthening the tax powers of the Parliament, and I certainly agree with that. I would like to see a few more taxes to devolve to the Parliament. In committee, this Cabinet Secretary said he wanted all taxes to be devolved to the Parliament. But I pointed out to him that this was actually Devo Max, but the Cabinet Secretary assured me he still supported independence. Now, of course, until we raise all the revenue that we spend, there will be the key issue of the block grant adjustment, which is not in the bill, but clearly that's going to be one of the major issues in the next year or two, and we wish the Cabinet Secretary all the best with his negotiations with the UK Government. I'm sure we would all urge him to get the best possible deal there. Now, there are many things in the bill that I welcome, including the process. I think it was a good process in committee and with the stakeholders, so I welcome the changes that have been made, for example, in relation to charities, the additions such as around non-residential leases, the general emphasis on attacking tax avoidance, and part of that obviously was dealing with reliefs such as sub-sale reliefs that encourage it, and also welcome the progressive nature of the bill. Of course, the first controversy that came up today was related to the rates, of course, and when they will be announced. So in a sense, that is still a live issue, since there's nothing in the legislation that says when that should be done. So I think the distinction between when residential rates are set and non-residential commercial rates are set is a very important distinction. Gavin Brown in particular emphasised the range of bodies who did think the commercial rates should be set earlier, and I was persuaded by that argument. I wasn't persuaded by the Cabinet Secretary's argument against that in terms of it has to be September, because when the budget bill comes in September, because there is a commitment of revenue neutrality. So in a sense, I don't see why the decision about the rates should be dependent on the overall levels of public expenditure at the time. I was also disappointed, obviously, about the energy efficiency, but no time to say anything else about that. And also, I think, about the partnership sections, which have been lifted straight from what is generally agreed to be a bad part of Westminster legislation, but he has committed to looking at that before 2015, so I'm sure that that will be done. Now, Kenneth Gibson mentioned grasping the thistle. I thought that was quite an interesting document, because a lot of the discussion of the bill has been about business, but that publication says that there is a lack of awareness in the business community and calls for a concerted programme of communication to boost awareness of the switch. Well, I'm sure it's not just the business community that need that, so I think communication about this will be important over the next couple of years. And of course, the other big thing is the practical issues that have to be sorted out. I'm glad, I think my time's up, I'm glad Registers and Revenue Scotland are making good progress, but clearly there are issues that concerned us at committees, such as, for example, who was going to give advice on the tax. So obviously the committee will be keeping a watching eye on progress in that area as well.
Thank you. John Mason, to be followed by Willie Rennie.
Thank you, Presiding Officer. It certainly has been a fascinating experience to see this bill making its way through Parliament, introducing this first new tax in this Scottish Parliament. I think it's both exciting and symbolic. As we start the process of replacing UK taxes with more appropriate Scottish taxes, it does no harm again to repeat the 4 principles for Scottish taxation, which the Cabinet Secretary has laid down, having drawn these from Adam Smith. Proportionate to the ability to pay, certainty, convenience and efficiency of collection. It's also worth saying again that tax is a good thing. We live in a world where many complain of paying too much tax, with the idea that for some days in the year everyone is, quote, working for the government, unquote. But that is clearly not true. We pay tax for the good of our fellow citizens. I do think we as a Parliament have a duty to argue for taxation and why it is both necessary and good. And to touch on a point that Gavin Brown made, although he's not here at the moment, I think, about witnesses coming to committee. Of course we have people come to committee with special interests, but we also have a responsibility to the wider citizens of this country, and they are not always at committee, and we have to take their view into account. On the bill itself, we've debated a number of issues. For example, I do welcome very much the principle of simplicity, and that the Cabinet Secretary has resisted the claims for a range of reliefs, which on the surface might appear occasionally attractive, but they could give an open door to those who seek to artificially avoid paying the tax. Secondly, and already this afternoon, we've debated the whole question about encouraging environmentally friendly housing, which we all want, but I continue to believe that the money would be best used rather than a tax reduction, but either targeting it as a grant or cutting the council tax. The question of the rates and when they should be announced has also been discussed. The block grant adjustment we have not spent a lot of time on, and this is an issue for all the new taxes, LBTT, Scottish Rate of Income Tax and Landfill Tax. And it certainly should be simpler to work out the formula for LBTT than, for example, the Scottish Rate of Income Tax. But we cannot have the same system for all 3 taxes, and the Finance Committee, I think, will want to be keeping a close eye on the negotiations between the 2 governments. Finally, I do think something very exciting is happening here today. For the first time in this Parliament, we are introducing a new tax. I accept it as a small tax, and it's replacing a similar existing one. But there is something very symbolic about this. Up until now, we have only had the block grant available to us, and we have had choices about how to spend it. But now, for the first time, we will be able to raise some of our own revenues. The ability to raise tax was a key issue on the road of the United States towards independence. At that time, London made serious mistakes in how it handled things. And Westminster has made serious mistakes too over the years in their quest to hang on to Scotland. Firstly, they made the mistake of giving us our own Parliament, which has only helped to boost Scotland's sense of identity and our ability to do things ourselves. And now they are giving us the power to raise some of our own taxes. And again, this could be a serious misjudgment on their part.
Be grateful if you could conclude.
The more powers we have and the better we use them, the more likely it is that we will go the whole hog and opt for complete freedom. So especially for that reason, I very much welcome the passing of this bill today. Thank you.
Thank you very much. Willie Rennie, to be followed by Jean Urquhart.
It's interesting that the independence revolution starts with the LBTT. That is obviously the most revolutionary development that has happened in this Parliament, and I look forward to joining John on that fantastic, exciting journey. It's also quite interesting that there's been many people who have mentioned that this is historic, it's a landmark, it's great enthusiasm that we have greeted this bill, but we shouldn't forget that this is part of the Scotland Act 2012 powers that was described by many ministers as a poison pill. They threatened to veto the bill. There were many red lines that were drawn at various times and then painted over with Tipp-Ex. But now we have this bill, and I welcome the bill because I'm in favour of more powers for the Parliament. But we should not forget that those who are enthusiastic about it today threatened the introduction of this bill. So we should not forget that those who sometimes are in favour of more powers adopt very strange positions. But for such an historic bill, I think we've adopted quite a timid approach to its implementation. I think we could have today implemented something quite interesting about trying to incentivise people on the environment. We've already missed our climate change targets, and I think we could have made some significant step today. But that was turned down, and that's a shame, and I hope the government reflects and also introduces other measures in other areas that tries to deal with the climate change targets that we have missed on 2 successive occasions. I do, however, welcome, because I don't want to be completely negative this afternoon, I do welcome the slab, the replacement of the slab proposal to something more in line with the income tax proposals, which I think is a sensible way to proceed and is obviously progressive. But I am disappointed that the Finance Secretary doesn't listen to the wise words of Gavin Brown and introduced much more notice for business and for others about how the tax was going to be structured. I think there's still an opportunity for him to give an indication. I hope he does, but I might be disappointed too. Thank you.
Thank you very much. Jean Urquhart.
Thank you, Presiding Officer. I must say, having heard the evidence sessions in the Finance Committee, I'm convinced of the merits of the Land Buildings Transaction Tax. Firstly, the slab system of rate setting and the stamp duty land tax is outdated and inefficient, and I commend the Scottish Government for striving to meet the 4 principles of tax legislation that it has committed itself to, in particular the LBTT's shift to a proportional and efficient progressive rate of tax. The evidence makes it all too apparent that land prices have been distorted by the slab system as it discourages the sale of residential property immediately above the thresholds, and the move to a progressive tax is a welcome shift in the current housing climate. I noticed that Willie Rennie's comments just now and the rejection of Gavin Brown's amendments, I think would be welcomed by the Scottish people, because that largely, you know, the tax dodging, which is so abhorrent to everybody in this country, and we realise how we struggle to provide good public services on endlessly reduced taxes, and they're recommending that in some of the areas where the most tax dodging was happening, that we shouldn't implicate these regulations. So I think that there has to be, this government is the first tax. It is a moment of history. And if I have anything any personal comment to make about that, it is that the 2012 Scotland Act actually having to introduce these taxes now is almost premature to a resounding yes result in autumn next year, where we will in fact be in charge of all of these taxes and not be dependent on however we deal with tax in this country, having to accept a block grant adjustment accordingly, which in effect could leave us no better off.
Final minute.
Well, just finally, Presiding Officer, I know, as I did at stage 1, that this is the first of 3 pieces of legislation emanating from the Scotland Act that will begin to increase this Parliament's powers. And I think it is important that we get this right, so to make another statement about Scotland's competency in regards to tax. And I look forward to the day that the Parliament has the full normal powers of the nation to bring about the substantive changes in our economy and society that we so desperately need. Support the bill.
Thank you very much. That brings us to the closing speeches, and I call on Gavin Brown. 4 minutes, please.
Thank you, Deputy Presiding Officer. John Mason said in his contribution that this was an exciting piece of legislation. And in a way, I have to say, I think he's right. There are elements of it that I think are quite exciting and quite interesting. The idea that we will be responsible for the setting of the rates and the collection of LBTT instead of just the expenditure, I think is a new development for this Parliament. It will force all of us, I think, as legislators, and the Finance Committee in particular, to step up to the plate a little. We'll also have to start to begin to understand concepts such as behavioural economics. What happens when you change the rate of a tax up or down? Do you get anywhere near what you think that you're going to collect? Do you get anywhere close to what you fear you may have lost? And I think that is an exciting development for the Parliament, and I look forward to the rates being set and the discussions ongoing up to April 2015 and thereafter. I obviously take a slightly different view from Mr Mason of where this will lead. He thought this was the beginning of the independence march. I take a slightly different view from him, but I agree with his idea that the concept is exciting. There is, Deputy Presiding Officer, still work to be done. I said that in my opening, and sometimes it can sound a bit trite to say that, but I do want to just get one specific example on the record just to show about the sort of thing I'm talking about that is contained in the bill. Schedule 18, which we looked at very briefly earlier, is in relation to trusts, and it is an area where some of the provisions from stamp duty land tax have simply been copied over. Part 2 of Schedule 18, paragraph 2, basically defines some of what beneficiaries are entitled to in terms of their interests in relation to the law of England. It basically says paragraphs will apply where property is held in trust on such terms that if the trust had effect under the law of England and Wales, a beneficiary would be regarded as having an equitable interest in the trust property. And I put that forward just as one minor example, but just to illustrate the point that despite there being much in the bill that is good, there are certain aspects that have simply been cut and pasted, and it is critical that in advance of April 2015, work is done via the various working groups and parties that the Cabinet Secretary has talked about. I would plea again that he says a little bit more into the setting of rates in his closing speech. I suspect he may not, but the reason I ask that is Mr Gibson, if I heard him correctly in his contribution, and he will correct me if I haven't, put forward the fact that everyone should pay less. Now, I just want to probe that a little and to ask the Cabinet Secretary, quite simply, is Mr Gibson right? I said I would take it, so yeah, sure.
Kenneth Gibson.
Thanks very much for letting me in. Well, all else being equal, if everyone pays their fair share and avoidance is eliminated, then people will pay less than they would otherwise be the case, is what
Gavin Brown, final minute.
Perhaps the Cabinet Secretary can confirm, though, in his closing speech, will everybody pay less, in his view, in terms of the rates that we will be faced with compared to stamp duty, land tax? We'd be very interested to hear about that. Deputy Presiding Officer, there is much to be commended in this bill. There is still work to be done, as we've already said, in particular around rates, but also in particular, as I said before, in relation to subsale relief. I do think that Jean Urquhart was particularly harsh on subsale relief in her contribution. Yes, it has been an avenue for avoidance, but I don't think we should be putting forward the suggestion that everybody who uses subsale relief has been using it purely as a way of avoidance. When you look at the forward funding proposals, for example, the reason forward funding is so popular now is because many of the banks are not lending in the way that they used to commercial property, and it has grown because of that. I just ask that we don't cut those avenues off and be too hasty about hitting the economy with that. Thank you.
Thank you very much. I call on Rhoda Grant, 6 minutes.
Thank you, Presiding Officer. And the Labour Party supports the principles of the Land and Building Transaction Tax, and indeed it's been an interesting debate this afternoon. It's really an example of devolution working well and affording the Scottish Government the opportunity to design a tax that suits its needs and redress some of the flaws with the current UK system. It'll be responsive to Scottish markets, especially our housing markets, and free us from the other market distortions that happen when that's levied more widely. It's a good example of devolution, of decisions being taken as close to those that are affected by them as possible, and one of the real benefits. I need to maybe take slight issue with people who have said we haven't had tax-raising powers before. We have. Indeed, this Parliament was set up with tax-raising powers. That we've never used them is maybe a point of fact, but we did have tax-raising powers. Also, others have said that this is the first tax we've devised. That's possibly correct, but we did devise the social responsibility levy, and I very much hope that this new tax will raise more revenue than that one did in the past, and indeed will probably never raise any revenue again in the future. Can I turn to energy efficiency? And I think this is maybe one of the main bones of contention within the debate today, that there was no cognizance taken of Malcolm Chisholm's Stage 2 amendments and indeed Patrick Harvey's Stage 3 amendments to charge differently for energy efficiency. And I think it would have provided the government with a tool to encourage efficiency measures. We know that the climate change targets have been missed, and this would have provided another tool in the box to deal with meeting those targets. And I feel very sure that we will come back to this in the future, and indeed maybe this Act will be amended to make this happen again. Can I turn briefly to sub-sale relief and welcome the Cabinet Secretary's points on this. I very much welcome the setting up of a working group to look at this and the provisos he's put in place to make sure that speculative land purchase cannot apply for sub-sale relief, and that there will be indeed clawback if people apply for it, are granted it, and then don't fulfil the terms of that agreement. And I think we would very much also agree that if it's the balance between relief and avoidance is not met, then maybe we don't pursue this further. But I welcome that he is looking at this in greater detail, but would put again the emphasis on making sure tax avoidance is not a part of this new tax. And indeed, tax avoidance has been a big issue with stamp duty, and we would also welcome the general anti-avoidance rule that's going to be part of the tax management bill to make sure that people cannot abuse tax arrangements in Scotland. And indeed, we would look forward to working with government to making sure that that is as stringent and rigorous as possible. Can I turn quickly to a point that maybe hasn't been raised in the rest of the debate, and that is Revenue Scotland and the Registers of Scotland working together, and indeed welcomed what the Cabinet Secretary said in his opening remarks about good progress being made on that front. But can I ask him not to take his eye off the ball with regard to the IT system, because we need a good IT system that will deliver this tax. It must be fit for purpose, and we know that the Registers of Scotland have had problems with computer systems, and their systems have not proved to be very efficient. So we would very much hope that the new system being devised for this purpose is indeed fit for purpose and can deliver the system we require. Malcolm Chisholm talked about the block grant, and again this is an issue that hasn't been discussed very much in the debate, but I think it is hugely important, because we know that we will face a one-off reduction in the block grant, and how that happens will impact on our future revenue. We need a fair settlement, and it will be for the Scottish Government budget to deal with the peaks and troughs that will come from devising this tax and what it brings in. But we need to be very clear that the one-off cut to the block grant is fair, and that we don't lose out on in that way. Presiding Officer, like others, I very much welcome the changes in the taxation system, looking at a much more progressive tax system. We heard many speakers today talk about this distortions that were caused by the old slab system as part of stamp duty land tax, where there was large thresholds and people tended to keep their prices below that threshold to encourage sales and purchase. This will be much fairer, much more progressive, and indeed starts at a larger amount, which reflects our market conditions. In conclusion, Presiding Officer, we very much welcome this bill. It's devolution in practice. It gives the Scottish Government the levers it needs to promote economic development, as well as giving them revenue-raising powers. And of course, it's always a challenge reaching the right balance between those two aspects of our economy, to raise the revenue needed to provide our public services, but also to encourage economic development. And we very much welcome the bill.
Many thanks. I now call on John Swinney to wind up the debate. Cabinet Secretary, if you could do so in 8 minutes.
Presiding Officer, I'm delighted that for the conclusion of the debate we've been joined in the Chamber by my colleague and friend, the Education Secretary, Michael Russell. He must have been sitting in his office hearing the term grasping the thistle being mentioned, and I have to disabuse Mr Russell that it was not a plug by Mr Gibson for an illustrious contribution to the debate than Mr Russell made, but more a thoughtful and comprehensive report from Ernst & Young about the issues around tax policy in Scotland, which is a very welcome contribution to the debate, as have been the contributions of colleagues to this final stage of the proceedings. If I could say to Mr Chisholm, earlier on this afternoon, before I came down to the debate today, I was actually viewing from the Government's archives the 1705 Act that I referred to. I have to say it's somewhat more elegantly presented than the purple sheets that are in front of me today as part of the final provision, but nonetheless, I think a very significant moment where the Parliament here in Scotland, for the first time, is able to exercise responsibility in the formulation of tax legislation that will be effective within Scotland. And John Mason, I thought, made a very powerful argument in his contribution to the debate about the purpose of taxation and the fact that it is our duty in Parliament to scrutinise the application of that taxation and sometimes to take a robust view about some of the information that is presented to us and to take into account the wider interests of, as Mr Mason expressed it, our responsibility to the wider citizens who may not be at the parliamentary committees that are hearing this evidence and taking these discussions. And Mr Mason's points about the purpose of taxation and the fact that it is important to fund public services lie at the heart of the aspirations the Government has brought to the formulation of this legislation. It also lies at the heart of the composition of the Tax Consultation Forum that I have now established, which brings together not a grouping exclusively of tax experts, although there are plenty of tax experts in that room, but also representatives of youth organisations, older people's organisations, of the people that represent individuals on low pay, to ensure that we have a challenging debate about the approach we should take on taxation as we acquire these wider responsibilities. And one of the characteristics that I have been anxious to ensure is reflected firmly in this legislation is that we start off in the first bill that we take forward in 308 years to legislate for tax in this country, that we establish the firmest, hardest line that tackles tax avoidance at the very beginning. And in this respect, Jean Urquhart is absolutely correct. We should not in any way give a signal from this bill that we are interested in anything other than good, strong tax compliance. And that's why, and I welcome what Rhoda Grant said in response to my comments about subsale relief. Whether we like it or not, subsale relief has been used as a mechanism for tax avoidance, and the comments I put on the record were designed to make it absolutely clear, while we're prepared to consider these issues and open to the issues that will be involved, if there is any possibility that we are going to open up an avenue for tax avoidance, then the Government will not go down that route. So our approach to ensuring the robustness of legislation is absolutely crystal clear. Now, Mr Rennie said in his contribution that he didn't want to sound all negative, although he did a pretty good job of trying to pull off the act in the process. I would simply say to Mr Rennie, if he was so desperately troubled by the absence of a measure to assist in meeting the environmental challenge, there have been limitless opportunities for that amendment to be put forward and to be considered and scrutinised. And I am not aware of a single Liberal Democrat amendment that came forward that would have assisted us in trying to resolve those issues. I'll give way to Mr Rennie.
Willie Rennie.
The Minister may find it difficult to believe, but actually partnership's not a bad idea. He increasingly finds it difficult, as you've seen today, with actually sensible suggestions coming from Gavin Brown that have been rejected. I work together with those of like minds. He just seems to reject them.
Cabinet Secretary.
That was a very elaborate Liberal Democrat way of saying I haven't lifted a finger on this debate. Now, I would also point out to Mr Rennie that he marshalled arguments about comments that we'd said about the Scotland Act provisions. I would remind Mr Rennie that the Scotland Act provisions substantially differ from the proposition put forward by the Calman Commission and advanced initially by the United Kingdom Government by the change to the mechanism of adjusting the block grant in relation to income tax varying powers, which we thought had a deflationary bias, and that position was deserted by the UK Government and the Holtham methodology was applied. So I think some of our criticism was well-founded to protect the legitimate interests of the people of Scotland. Now, we're getting another intervention from Mr Rennie, so I suppose we'd better be gracious and generous to give him a platform, since he's not been involved in the debate for some considerable time.
Willie Rennie.
Will the Minister deny that actually he did describe the Scotland Act as a poison pill, as dangerous, and he was prepared to veto the bill? He had 6 red lines. Those 6 red lines completely disappeared. Will he not admit that?
Cabinet Secretary.
I don't think it's a great place for unionists to talk about red lines in this Parliament. There were all these red lines in the sand, and they've all gone away again. And as for Mr Brown said that Mr Mason was making a kind of undue link and leap between the Parliament getting tax powers in this respect and then getting on to get further tax powers. I would gently remind Mr Brown that his party was against the establishment of this institution. It said, thus far and no further. Thus far and no further. Thus far and no further, and they gave us the Calman Commission.
Order, please, Cabinet Secretary.
That was apparently designed to put our gas at a peep, and then they came around after the election when we won a majority, and with the line in the sand, we had to go on to have more power. So I don't think the Conservatives are in a strong position to tell us or to lecture us about how one power of responsibility being transferred here does not lead to further
constitutional please, till we hear the end
change.
Of the Cabinet Secretary's speech.
All I would say to Parliament is that this is a very significant day. It is the first day in 308 years that this Parliament has had the opportunity to formulate legislation about tax, to implement tax in our country. We believe that that is an indication of the strengthening of Scottish democracy, and it will be complete when this Parliament has all the financial and economic powers that come with being an independent country.
Thank you, Cabinet Secretary. That concludes the debate on the Land and Buildings Transaction Tax Scotland Bill, and it's now time to move on to the next item of business, which is consideration of motion number 6730 in the name of John Swinney on the financial resolution for the Victims and Witnesses Scotland Bill. I call on John Swinney to move the motion, Cabinet Secretary.
Formally moved, Presiding Officer.
Many thanks. The question on that motion will be put at decision time, to which we now come. And there are 3 questions to be put as a result of today's business. The first question is that motion 7106 in the name of Paul Wheelhouse on the Crofting Amendment Scotland Bill be agreed to. Are we all agreed? Yes. The motion is therefore agreed. The second question is that motion 7107 in the name of John Swinney on the Land and Buildings Transaction Tax Scotland Bill be agreed to. Are we all agreed? Yes. The motion is therefore agreed to. And the next question is that motion 6730 in the name of John Swinney on the financial resolution for the Victims and Witnesses Scotland Bill be agreed to. Are we all agreed? Yes. The motion is therefore agreed to, and that concludes decision time. We will now move on to members' business, and I would ask members who are leaving the chamber to do so quietly, please.